Good afternoon and welcome to the Appellate Division First Department. Before I begin with the call of the calendar, please know that there is already 6 hours of argument time requested. So I'm going to ask that you please ask for the time that you actually need, not the time that you want, understanding that we are fully familiar with your case, the briefs, the facts, and the record. Please also understand that if I cut your time, which is likely to happen, that the time clock is for you, not for the court. So if your arguments are brilliant and my colleagues have additional questions, I will not interfere with their need to ask more questions, okay? That being said, People versus Anthony Baez.
Good afternoon, Your Honor. Appellate request 5 and 2.
Okay. Let's do 5 and 1 and 5. And again, it may go to 2, but. Robertson Fish versus Fish.
Good afternoon, Your Honor. For the appellant, Robertson, 8 and 2, please.
Okay.
Good afternoon, Your Honor. For the respondent, 10.
All right, let's do 6 and 2 and 6. And like I said, I'm sure you'll be brilliant, so I'm sure it'll go over that time. Migdalia versus Lucero. Submit. Wesco Insurance versus Jewelers Mutual.
Good afternoon, Your Honor. Appellate request 5 and 2.
Okay.
Good afternoon, Your Honor.
All right, 5 and 1 and 5. People versus Jose Rivera.
Good afternoon. Appellate request 5 and
5 and 1 and 5. Gurnie Goldman versus Sila Management. 5 and 1 and 5. Harrum versus Montefiore Hospital. All right, I just want to make clear that the defendants have to share 15 minutes of time. So I hope you've made that consideration in your application request. So now let's proceed. Plaintiff? Okay.
Respondent, appellate Montefiore Hospital, 3 minutes.
Okay, so I believe Montefiore and Flo have the least skin in this game, so you're getting 2 minutes each. Everyone else, 3 minutes. Okay? All right? I said, 6 and 2, sorry. All right. People versus William Perry is submitted. E.W. Howell Company versus Hill International. Okay. All right. 6 and 1 and 6. Fineberg versus 72nd Tenants Corp. You weren't listening to my instruction in the beginning, but go ahead. Okay. 4 and 1, 4, and you asked 4? I'll give you your 3. 4 and 1, 4 and 3. Okay. People versus Raimundo Figueroa. Submit. Zimmerman versus Stevenson.
Good morning, Your Honor. Appellate request 5 and 2.
Okay.
Respondent, Michael Zimmerman, request 3.
You have a cross appeal?
Oh, I'm sorry, no, just 3.
Okay. 5 and 1 and 3. 154 East 62nd LLC versus Norus Realty. Okay.
Your Honor, respondent, request
All right, 6 and 2 and 6. People versus Ashanti Holmes. All right.
Respondent request 3, Your Honor.
5 and 1 and 3. Silver versus Baker Botts. 5 and 1 and 5. GKER Limited versus Clarkson is submitted. Mon versus Molman is submitted. First case on the calendar, People versus Anthony Baez. Please come up. And you may proceed.
Good afternoon, Your Honors. My name is Brian First from the Center for Appellate Litigation, and I represent Anthony Baez. Mr. Baez's purported waiver of his right to be present was invalid. This case can and should be resolved by a straightforward application of Parker, which held that for the right to be present to be waived, the court must act.
What was wrong with the court's allocution when asking your client all of the questions concerning whether they could proceed in his absence and his affirmation that they could?
Well, Your Honor, at that time of that colloquy, the only question that he asked him was whether whether his attorney could proceed in his absence. That's it.
Well, what else is there?
Well, Parker.
In light of the fact that there had been multiple warnings already administered.
Well, but the Parker warnings were bad at each instance, Your Honor. Parker is clear that the court has to inform the defendant both of the nature of the right that they're being asked to waive, the right to be present, and the consequences of failing to appear. Here, all the court did was inform him of the consequences, and inaccurately at that. When he was giving his Parker warnings, instead of telling him that he had a right to be present, he said, I invite you to return every day to assist your attorney. That is plainly inadequate, right? It's not, Mr. Baez is not there on the court's invitation. He's there because it's his constitutional right to be there, right? And so my colleague won't be able to point to a single instance in the record where the court even tells Mr. Baez that he has a right to be present, or
isn't it
explains
implied
nature
by
of
the,
that right.
I'm sorry, counsel, isn't it implied by the fact that he asked counsel's consent?
That he has counsel's consent?
I mean, excuse me, he asked the defendant's consent, pardon me.
Well, first of all, Your Honor, we can't, there's no case law that we can imply that a defendant understood the nature of a constitutional right to make that
Even
right
after
knowing.
repeated.
But he
Counsel, repeated.
Repeated what, though, Your Honor? He didn't, everything he said was incorrect. He never once told him that he had the right to be present. If he had repeated that, okay, sure. But he needs to inform him, per Parker, of the nature of the right to be present. And at no point did he do that. And that is dispositive. Without that, there can be no valid waiver of the right to be present, right? If we applied this case, this colloquy to any other constitutional right, it would be plainly inadequate, right? If we're talking about the right to counsel, the right to trial, waiving that by pleading guilty, the right to, waiving your appellate rights, the court would never just ask.
Counsel, prior to the colloquy with the defendant, his counsel also represented that, quote, we can go on without him, close quote.
No, his lawyer objected, Your Honor, and said, I do not want to continue in my client's absence. He objected.
But prior to the colloquy, didn't he say that to the judge?
Prior to the colloquy, he said that his client, that Mr. Baez, had said that in the bathroom so that we can continue, but that doesn't make Mr. Baez's waiver any more knowing or intelligent. I'm not disputing that, yes, he said you can continue in my absence. The problem is that waiver has to be intelligent. And under the standard in Parker, there's no way we could find it intelligent.
So chapter and verse, what should the judge have said?
The two things, Your Honor. First, he should have given a correct Parker warning. He shouldn't have just given his own Parker warning. He should have given the model Parker warning. He should have told Mr. Baez, you have a right to be present at trial, and he should have told him that.
You're saying he never gave that full charge?
Not at all. Not at all.
Ever?
No.
In any of his Parker warning charges prior, let me finish my statement,
I'm sorry, Your
please.
Honor.
prior to the commencement of trial, which is typically the first Parker warning that a judge will give, right? You're saying he never read the full charge?
No, he did not.
Okay.
What he said was, we're going to do the hearing, we're going to do the trial. I invite you to come back every day to help Mr. Damien in your defense. But if you decide not to come for whatever reason, three things can happen. The trial can continue whether you show up or you don't. If you're convicted, you can be sentenced, and depending why you're not there, there can be additional charges.
And which case do you depend on that requires a particular litany?
It's not a particular litany, but Parker says, it's Parker, Your Honor, that is the case here,
Okay.
that there must be some explanation of the nature of the right to be present at trial. And here, there wasn't in any time, any way, shape, or form that information. So to Your Honor's question about what the court should have done, first he should have given the correct Parker warning, but at the time of the colloquy, when Mr. Baez was actually waiving his right to be present, at this point the court has determined that Mr. Baez actually is ill, right? And so at that point he had the obligation to give a more complete colloquy when he's taking that express waiver.
All right. You'll have time on rebuttal.
Thank you, Your Honor.
Counsel, you may proceed.
Thank you, Your Honor. Stacey Nadell for the people. The court's Parker warnings, multiple Parker warnings here, were sufficient in terms of the Parker case. The court was very clear in explaining the nature of the right, which is what is required by the Parker and its progeny.
The court ever characterize it as a right or an invitation?
It wasn't so much, it was definitely not characterized as an invitation. It was explained, again, in no particular litany, but the court did say, this is what can happen if you don't show up, this is what will happen if you don't show up, essentially explaining the nature that if you don't show up, this will happen. And I think it was definitely...
I guess the why is important, right? The why these things can happen and why there are alternatives is because it's such an important right. And so was it ever communicated, in your view, in any of the various iterations of this warning that the defendant had this right, this very precious right?
It was communicated that that the defendant should be there and must be there, and these things will happen if they don't. Perhaps the why wasn't explained in full detail, but that's not what's required under Parker. What's required is that the nature of the right is given, the defendant is fully apprised, and if he waives it, he can do so explicitly or implicitly, which is what happened here. The defendant waived his Parker rights both explicitly and implicitly. During a break in the proceedings on that fourth day of trial, June 19th, 2019, the defendant left the courtroom and said he didn't want to come back. He told the court officers, I don't want to come back. I'm feeling sick. My attorney can proceed without me.
Am I correct that this was the only day that the court proceeded without him?
That is correct, Your Honor.
That there were other days in which the defendant did not appear and the court adjourned the matter because there was no explicit ability to confer with defendant on the record as to whether he waived his right on that day.
That is correct, Your Honor.
So that the only day that the court permitted the proceedings to proceed was after this defendant's waiver of his right on that given day.
That is correct, Your Honor. And he did so to the court officers, to his defense attorney, and in that colloquy on the record.
Well, for the record, the fact that he said so to the court officers is irrelevant.
It's irrelevant, but it's still, it's not irrelevant. It still goes to the fact that the defendant showed that he was not coming back to court and that his attorney could proceed in his absence. It's evidence to show that he did intend to waive his Parker rights.
So when I say it's irrelevant, but for all of the other indicators on the record and otherwise, had the only information the court received was just from the court officers, that would not have been enough. Can you agree on that, counsel? If the defendant does not on the record say, I understand that I'm waiving this constitutional right, the fact that he has a hearsay conversation with the court officers would not be enough on the record.
Alone, maybe, but if he absolutely refused to leave the bathroom, if he got himself back on the bus to Rikers and just refused to come back to court, that would be an implicit waiver of his right because he was knowingly failing to show up for the court proceedings.
But then again, he came into court. He came into the courtroom, and the court asked him, the judge asked him,
if he wanted to absent himself and if his attorney could proceed in his absence. And he said yes.
Yes. Correct.
So it would be irrelevant, that conversation that we're having about the court officer having a hearsay conversation with the defendant does not apply here, because in this case, the defendant came into the courtroom and he was questioned.
That is correct, Your Honor. Yes.
Thank you.
So where we have the explicit waiver, where the defendant said agreed with the court multiple times, I am willing to let my attorney proceed in my absence in response to the defendant's question, it was very clear that it was up to the defendant, and he exercised his right knowingly, intelligently, and voluntarily.
Thank you.
Thank you.
Your Honors, the people are confusing in the Parker warnings the consequences of not appearing with an explanation of the nature of the right. And Parker makes clear that you need both. At minimum, Parker says, at minimum, you need both of those things. And you only have the consequences of not appearing in this case. You never have any explanation of the nature of the right. The people in all of their briefing, and just now, they never cited to anywhere in the record where the court says, you have a right to be present, and explained anything about that right. So no matter if the waiver was implicit, explicit, the waiver has to be intelligently made, right? He did, yes, he said you can continue without me, but he must make that waiver intelligently, and that requires the court to say, tell him, explain to him that he has that right to be present. And in this context, when he's sick and he's too sick to appear at trial, the court has to tell him, we can adjourn. We can adjourn until tomorrow. Knowing that, do you still wish to waive your right to be present? And if he said
But he
yes,
did that.
then-
He did do that.
He did not, Your Honor.
Not at that precise moment, but on another day, when the court wanted to proceed, it did not proceed because the defendant did not consent to having the trial proceed in his absence.
Exactly, Your Honor, and that shows, because this is after a 45-minute conversation that he had with his defense attorney. This was his defense attorney put on the record, he refused to waive. So it shows that when he's actually informed, when he understands the
No,
right-
it doesn't show that, because we don't know what the conversation between him and his attorney were.
Well,
you are assuming and asking us to assume that there was a conversation that entailed information that you are suggesting the judge should have communicated. And we don't know that as a matter of fact, because it's not in the record.
Well, Your Honor, I agree that the conversation he had and the subsequent refusal to waive his right to be present is irrelevant to the question of whether his waiver at that
That's
time.
not what I said, but you can continue with your argument.
I agree with you. If we're, I'm just saying, I'm just responding. If we're going to,
No, you're not responding. You're making another statement. I have no problem with that.
Yeah.
But I don't want you to make the statement as though you are responding to what I said.
Okay.
You are not. You are making another argument. And as I said, I have no problem with that, okay?
Thank you, Your Honor. And so I don't think that whatever happened on that day, 4 days, or when he refused to waive, is relevant to the question, did he know, did he understand the right that he was waiving at that time? Because as Your Honor just said, we don't know what he knew at that time, days later. We don't know what that conversation was. It is irrelevant to what happened in the courtroom. What is relevant is what did the judge tell him? And the judge did not give him enough information to make a knowing and intelligent waiver.
Thank you.
Thank you.
Robertson, Fish versus Fish. You may proceed.
Good afternoon. I'm here on behalf of the appellant. Your Honors, as must be obvious, I've been doing this for a very, very long time.
It's not that
I've
obvious.
never quite seen a decision like this, in which the major findings in the decision were never sought by the respondent. There was no indication that any of the findings of the judge below were being sought on the principal issues. Nevertheless, the trial court decided those issues and did not give any opportunity for the appellant to prepare for that and to serve papers and to deal with the issues before the court. That's what has happened in this case. Judge Chesler made sweeping characterizations of calling my client a domestic abuser. There's never been in the 2 years of litigation in this case.
Counsel, you're not disputing that the automatic orders were violated by your client.
We are disputing that, Judge Moulton. The fact is that those automatic orders don't go into effect if they're in the ordinary course of business. And as the brief said,
How is purchasing personal property part of his ordinary course of business as an private equity investor?
Your Honor, private equity, being in the private equity business means you invest.
I understand. I fully understand. Trust me, I understand.
I'm sure you do. I don't.
Okay, but so does that mean that every possible business in the world that a private equity firm can invest in now becomes part and parcel of his business? That seems to be a bit much. And that's not to at all address the other issues you started with. But just specifically to your argument with regard to what your client did in purchasing property for himself, for him and his family, is part of his private equity business, I think is a stretch.
Judge, it's part of his real estate business. Fortunately,
But wait. Personal. Look, I don't begrudge anyone the right to use your own personal wealth to invest as you please. And if he chooses to do that in real estate, good for him. I don't disagree with that choice. But that's not the issue, right? The issue that you are raising is that somehow his purchase of these properties in the Hamptons was a private equity purchase as opposed to a personal purchase for himself and for his family's.
For some 30 years, the appellant has been investing in real estate, both residential and otherwise. There were 2 homes in New York City.
Now, when you say that, do you mean investing in property for himself as opposed to the business?
Judge, real estate is real estate.
No, I understand that. But whether you buy it with your own personal money means it is a personal investment. If you buy it with the money from your private equity business, then arguably you can say it is for the business.
Judge, I refer you all to page 615 of the record, in which there's a page of various real estate investments that were made by our client. And the fact is that he's made money both in investing in real estate, commercial real estate, and funds, and in his personal real estate. Nobody owns 5 houses to live in, Judge. They had at one time they had 5 residences in the Hamptons. Yes, there's a lot of wealth in this case.
There are people in the 1% that do own multiple houses.
Judge,
There are. Okay, we can. I'm not one of them, but there are, right?
But Judge, part of a net worth that gets distributed at the end of the day in these matrimonial cases, part of that is both residential real estate and both commercial real estate.
I'm sorry, but before the red light goes on, there's a more fundamental issue here. And that is what was sought and what was granted was an advance on equitable distribution. And I'm not familiar with any authority that permits an advance absent necessity.
Judge Higgett, that you brought that issue up. There's a Court of Appeals case that came down just in October of 2024, which defines what you have to do to create equitable distribution. And the court went on to say, and I know I don't have much time left, but the Court of Appeals.
Don't worry about that.
Okay, thank you, Judge. The Court of Appeals said, in order to award equitable distribution, you have to make a searching investigation of the marriage, of the assets, and they went on to say how much time needs to go in. There was no time in this case, Judge Higgett, that the court below made any finding, and they didn't call it advance. He said it. I think the opinion said he was granting equitable distribution of 29, of 29
Mr.
million.
Roberts, I don't mean to cut off. I'm sorry, Mr. Cohen, I don't mean to cut you off. May I ask?
Judge, anything you want. You're sitting up there, I'm down here.
He's asking me.
Okay.
Oh,
Several points. We understand that the wife brought an order to show cause because she learned that your client took approximately $30 million, allegedly of marital assets, to buy adjoining homes surrounding the Hampton properties.
Can I just answer
Well,
that?
just bear with me for a moment.
Sorry, Judge Shulman.
Whereas the automatic orders require that you either get consent or an order of the court for such a purchase. So that was the setting for this whole court proceeding, correct?
With exceptions, Judge, of the automatic orders. One exception is if it's in the ordinary course of business.
I understand. So
And I said that. And the other exception is if he's using his separate property money. We made that argument.
you made the argument, Mr. Cohen, but on this record, as I understand it, they managed to produce a forensic expert that establishes that the purchases were made with both marital and separate assets, which was one of the issues that was part of the finding by the court.
I'm glad you said that, Judge. The expert's affidavit came on reply. That expert's affidavit under law in the appellate division in this state, you cannot use an expert's affidavit on reply, which we had no response to. That expert's affidavit, I don't know whether it was relied on or not, but should have been ignored. We cite the cases in our brief, and they deal with expert testimony. You can't put it in on a reply.
If we were to ignore that, can you tell me where in the record your client establishes by evidence, other than just saying so, that this purchase of the additional $29.6 million property was post-marital assets? What proof is there in the record that the funds utilized to purchase that property were indeed post-marital assets as opposed to marital assets? What proof
Well,
in
first,
the record, and tell me where it is so that I can go look at it?
okay, Judge, I can't give you the page on the record because I don't have it in front of me. We have 4 volumes of a record here.
Well, if you
But-
can't
but
find it,
I'm-
then I can't.
No, or somebody in the court could find it, Judge. But I will get it to you. But to answer your question, those purchases were made obviously after the commencement of the action. They were, our client set forth in the papers before the court that he was using, he isolated separate
Yes,
property
but
money.
That's what I'm saying.
But there were,
It was just an affidavit by him. There's no documentary evidence that establishes that indeed the funds utilized to purchase this $29.6 million property was indeed purchased with just post-marital assets as opposed to what the plaintiff is saying, which is both.
so it's even. The plaintiff says it wasn't separate property. We say it is. There should have been a hearing here, Judge. Yeah, look. The papers were submitted. These were not even issues before the court. How could we even request anything? The idea that he was going to be called a domestic abuser, which permeates the entire decision in this case.
I don't disagree with you, okay? But I don't understand how and where in the record there is any evidence that the funds utilized to purchase the property were indeed post-marital assets. And since your time is up, I'm gonna give you some time while you're sitting and we're hearing the other side to look at that and give me an answer.
I'll try, Judge.
All
Thank
right,
you.
great. All right. Counsel, you may proceed.
Good afternoon, Your Honors. Thank you for having me. To address what you were just discussing, first of all, the expert affidavit that we submitted on reply, they actually submitted a reply to that. So the arguments were that they didn't get a chance to respond to it. In the record, they did submit a responsive affirmation. They didn't respond to that at all. Also, in the record, I'll cite you to 478 in the record. That is the day he sends $11.5 million to buy this new house. The next day, in the record, 475, he just takes $7.4 million from the marital account and just ships it over to his separate account. That's the next day after he sent that money.
Sir, we're in the weeds very deeply.
Sorry, I was
On the record as far as whether the orders were violated, the degree to which they were violated. I'm not even in the garden yet because I haven't been able to find a case where an advance on an equitable distribution has been permitted outside of necessity is the word that the courts use.
Your Honor, there are a few cases, and I'd like to address it. The first thing that's different here, we asked for an advance against equitable distribution, period. If you look at the decision, what Justice Chesler did in both...
No.
No, in the... I'm
No,
addressing this-
wait, because my colleague is asking a very pointed question. What is the authority? We have seen no cases like this.
Howell versus Islam is one. The other case, but if
Which
I could...
talks about necessity.
Can I just...
In the decision is the word necessity.
Yes, we cited some other cases, Your Honor, including the case Balkan, where the wife sought and received over the objection of the husband an advance of $2 million. But the difference here also, if I was going to just specifically answer your question, Judge, is that Justice Chesler noted this is an advance subject to reallocation.
So why don't we see this with great frequency in matrimonial litigation?
Well, you see the courts in a number of cases for purposes of equity trying to address what's happening here. And so if you step back, you have $1 billion of assets. You have $1 billion of assets, and the argument is if you let the wife have 3% of those assets, somehow there's going to be a floodgate.
But that is not the standard of law that we are to employ in deciding whether this is appropriate, is it?
I think what the unique nature of the case.
And what's the uniqueness?
That they're rich?
No. The gross violations of the automatic orders.
Okay.
Well, right, well, wouldn't that have triggered some kind of contempt proceeding? For example, when you came in, that's why I asked your friend, you filed an order to show cause to say, hey, court, my husband violated these automatic orders and wrongfully took our marital assets to buy 2 properties surrounding my properties in Further Lane and Space Lane in the Hamptons. And I want sanctions. This was not a case where you were seeking advance so she could buy another home because she was unhappy with someone using her primary bedroom in the Further Lane home. You may have had other concerns about that. But so then the court looked at the picture and fashioned what he thought was an equitable remedy because of the financial power that was on the other side of the table. The question as being raised by all of us here is, what was the authority for the advance now? What was the equity to give her some kind of financial power to buy her own home, even though she had exclusive possessions of 2 townhouses, even though she was getting $29,000 a month in maintenance, even though she was covered for a lot of her daily living under these circumstances? We're trying to figure out, where did this remedy come from? What is the justification for it?
I think that the remedy came from, Spector talks about that for the violation of an automatic order, the court can have equitable relief or legal relief. And what the court here said was, Mr. Fish came to the court and concealed, specifically concealed, not just one purchase, 2 purchases of homes, $13 million worth of art, a $29 million purchase, a $13 million purchase, that he alone exercised total control, would dole out a certain amount each month, which, by the way, he announced to his wife that was coming from the marital estate. And if you remember, it's in the record, at the same time as he was going on this incredible spending spree, he was representing to the court that he didn't have money to pay for the basic living expenses. So,
is it unique in matrimonial litigation that one spouse wastes or spends money to the detriment of the other spouse?
the automatic orders are intended to prevent that.
Okay, and they've been on the books since 2009, is it? Somewhere in that neighborhood? Okay, so they're not brand new. Are there examples in the case law where there were violations of the automatic order?
Yes, Your Honor.
Okay, and was there a remedy that has been recognized in the case law?
The case law talks about either equitable relief or legal relief. So for example, there's cases where we say we can change possession. When someone has violated the automatic orders, there's a case that said, fine, we're going to change possession. We're going to let the wife be the custodian of these assets. And we cited that case. Right?
Was that an example where she got exclusive use of the primary bedroom and no one's allowed in it? Is that the equity you were seeking?
No, we were
Among
actually,
other
we were
remedies?
actually seeking to what the judge did, which was to untip the scales, which was to say he has unbridled control and possession over all of these assets. Let her have 3%. Let her have.
But that's not what you sought at the outset.
No, we absolutely did. Our application sought, did specifically seek that advance, $29.6 million advance. We said, let her be made whole. He has violated the orders. Let her be made whole, not for all of his violations, just for one, not for the $240 million, $240 million that he
Is
removed.
29.6 million being made whole?
Not even,
If the property is worth 29.6 million, and one can assume that each person in the marriage would have 50% of that, then at the very least, we're talking about half of that number.
I don't think so, because
How can you say that?
because he took $29.6 million. He also took $16 million. He also bought $13 million of art.
And all of this would get settled out at the end of the trial.
Then-
That's
I'm sorry, Judge, I didn't mean to interrupt you.
right. I mean, we do this all the time.
To countenance this behavior is to essentially say there is no consequence to a violation of the automatic orders. That this,
I don't disagree with you. So for me, the issue is not whether there should be something that the defendant must be made to pay for, right? For lack of a better word, right? But is the solution that the court came up with and that you are suggesting the right one is really the issue?
well, I think that solution, the trial court is vested with the power to do equity. And
So we really don't need we don't need the equitable distribution law then. I think that's a very demeaning statement to make to the legislature, who has a very detailed scheme under 236. And I assume at the time the various times they've studied this subject, it's not that it didn't dawn on them that there couldn't be an advanced distribution. They saw fit to only permit an equitable distribution on final judgment.
So the advance here, the fact that it says it is subject to reallocation, simply means my client gets possession of $29 million out of the $1 billion just during the pendency of the case. At the end of the case,
So this is a rule, because we will be, I think, recognizing an exception now, in addition to the necessity exception, which I think we all would agree serves a very salutary purpose. I agree with you that the conduct you've described calls out for some sort of remedy. The concern is it's not just this case we have to be concerned with, it's the legion of other matrimonial cases that are going to be subject to this precedent. And so the rule then would be a de minimis, for the violation of an automatic order, a de minimis advanced distribution is permissible if, and Phil, you provide me with the end of that sentence.
I think there could be a number of them within the discretion of the court of the amount that someone has improperly transferred away. That's particularly if it's a de minimis.
Wealthy litigants will get a broader standard of justice for advances than the average litigants who aren't going to be dealing with marital estates of anything approaching this size.
I think the same would apply for smaller estates as well. And probably even as important, if in a smaller estate, a spouse, first of all, not only takes an asset, but then falsely makes representations to the court about it, and also says, by the way, I'm just going to keep doing it. That was the other thing here, is this husband said, I can keep
This
doing it.
sounds like something familiar, contempt. And there's a cognizable, well-worn remedy that has standards for it.
Your Honor, I think that the reason that the violation of the automatic order gives the trial court discretion to fashion an equitable remedy is because every case is in fact different. And here what this court did is say, look at the imbalance. Look at the imbalance. Why shouldn't the wife at least have 3% of the estate? And I say, if the husband in this case, talk about the institute the concerns for the system. If this is permissible, then literally anything is.
But it's not, there's a sanctions hearing coming up, correct?
There was a
Also,
sanctions hearing.
the court scheduled a sanctions hearing, which also seems to me inconsistent with the summary relief that he gave your client. Why have a hearing on sanctions when you've already awarded $29 million?
I think the difference is we were not actually awarded $29 million. We were given possession.
By the way, where is I know we did not stay that order, so where's the money now?
It's in our client's possession, Judge. Our client was simply...
All right, enough. We've gone way over. Thank you. We have your arguments.
Thank you, Judge. I want to answer several questions that have been asked by the bench, and I'm going to do it very quickly because I don't have a lot of time. The Howell case, Mr. Wolf gave us an example of giving money out before there's an equitable distribution. In Howell, the husband tried to kill the wife. He came home at night. The wife told him she didn't want to be married to him anymore. He took an andiron and tried to murder her. He had no money to pay counsel fees. They gave him some money out of the equitable distribution, out of the assets that existed for counsel fees.
That was a case of necessity.
Sorry.
It was a case of necessity. He didn't have funds to pay for his criminal
Every
defense.
case that was cited was a necessity. There was a mortgage that was due, and the couple didn't have the money to pay the mortgage. They let some money come out of the.
So Mr. Cohn, if these properties weren't purchased, there would not have been an application for an advance, correct?
There would have not been, well, there wasn't no, there would not have been. I think that's correct. But I want to cite you to the Court of Appeals case in October, which we didn't cite because it came too late. The name of the case is Spulla, S-C-P-U-L-L-A. And I'm sorry, I can give you the miscellaneous site, 4 Miss 3D 1210A. Very, very precisely.
Sir, is your friend really being left without a remedy here in light of the serious, significant allegations they've made about the use of a significant amount of money? Is his client being left without a remedy here? If there is let's assume, just humor me if you will, there's a clear violation of an automatic order involving the expenditure of $30 million. What is a litigant in his client's position supposed to do?
So the answer is, Judge, if that happened, there was plenty of money. There was plenty of money. Mr. Wolf and his client called that amount de minimis. The court called that amount de minimis. The reason for, and I think this is very important, if you look at the Sykes case, which was a long decision on the automatic orders, read it. The major reason for passing this automatic orders was because they didn't want the assets to dissipate. With a net worth of about of this family of $800 million, the idea of spending $29 million is not going to dissipate these assets. There was a case cited. It was a case that I tried actually, the Sykes case. There was a $3 million house purchased by the husband in violation of the automatic orders. They admitted that, the other side, the husband's lawyers admitted that it was in violation of the automatic orders, and there was no defense to it. In our case, we're forgetting that he claimed it was separate property, and Your Honor, I know you asked me for a cite. I'm going to tell you the pages on the brief. Did you get? Anyway, it's dealt with the brief. I couldn't pull
It's
4
okay.
volumes.
I understand.
So yeah, there has to be a dissipation of assets, and there's no dissipation of assets here, apart from the fact that that our client said it came from his separate property, and that there was no commingling, and the court should have, with what was involved in this case and the new evidence that he created out of whole cloth.
You're saying you should have had a hearing.
He should have had a hearing. That's what happens when there's a dispute. The court below found that because my guy is in the private equity business, that he couldn't be in the real estate business. And that doesn't make any sense. Private equity business, as you all know.
Counsel, again, we're not going to go through that argument again because that argument says that your client can spend money wherever he wants because he's in private equity, and I don't think that that's what the law says. But we've got your arguments and the record, and I thank you both.
Thank you, Judge.
Wesco Insurance versus Jewelers Mutual.
Good afternoon, Your Honors. Max Gershwire for the appellant Wesco Insurance Company. This is something of a deja vu moment for me. This is the 7th time I've argued this very issue before the court. And even though on each of those occasions and on every other occasion that this court has addressed the issue, the result has been the same, the finding of coverage. The lower court, without any explanation whatsoever, found to the contrary.
Well, I think there's plenty of reasons here. So let's go to the lease.
Sure.
Right? The lease very specifically says that this seller is not a part of the duty of this, the underlying store, Rio de Oro Jewelry, had no obligation with regard to the seller. And the seller is around the corner from the entrance of this store. The wall where this cellar door is has no windows, no doors. The only access into the building is that cellar door. And the lease very clearly says that Rio has 0 obligations with regard to that premises because the basement and the cellar is not a part of their lease premises, right? And the insurance contract here says very clearly that they are only insuring the leased premises and the seller isn't part of it. So explain to me how this falls to Rio instead of the tenant who leased that
Sure.
seller.
Judge, if the issue here, if we were here in the personal injury case, all of this would be relevant to which party is liable for the condition.
Is there language in the insurance contract that says something about only in the personal injury context? I didn't see any such language. If there is such language, please tell me so I could go look at it.
My point, Judge, is that what you're speaking about, the issue, the evidence that you're talking about is relevant certainly to liability. But what we are litigating in this case is not liability. It's not a question of whether it's the landlord or the tenant who is liable.
No, we're talking about whether the seller and those cellar doors that give access to the cellar are part of the lease premises of the insurance that your client is trying to reach. And both the contract and the lease say otherwise. So explain to me how you get around that.
Sure. The question before the court is whether the additional insured provision covers the landlord for this incident. So the relevant language is not the lease. It is the additional insured provision.
And what does the additional insured provision say?
It says it covers the lessor for liability arising out of the ownership, maintenance, or use of the leased premise.
Of the leased premises. Right. And again, tell me what evidence is there in the record that the seller is part of the leased premises of Rio Jewelry?
Judge, the lease...
It has to be in order for your argument to win.
I respectfully, Judge, I disagree. This court has consistently found that this additional insured provision covers liability for accidents that do not occur on the leased premises. There is no requirement in this provision that the accident occur within leased premises. If that were a requirement, then in none of these cases that I've argued before the court, and the court has found in my favor, would there have been coverage, because every one of them involved injury that occurred outside the leased premises. What is relevant instead is whether it arises out of.
So are
It's a
you
very
saying
broad
that in
language.
all of those cases that you won, that none of them said that included the facts here where the leased premises did not include the situs of injury?
That's right. All of these cases that I'm speaking about involved a public sidewalk. A public sidewalk, by definition, can't be part of a leased premises. It's owned by the city.
Arising out of, in this case,
In
you're
New
using,
York City, that is
counsel, you put emphasis on arising out of, that's arising out of the ownership, meaning
Correct.
your client's, the fact that they own the whole premises.
Right.
So it does, his liability arises out of his ownership status. It doesn't arise out of an injury that happened on the premises leased to you, premises leased to you, i.e. to Rio.
So the way that the courts have explained it in finding coverage in every case where there is a public sidewalk accident is that the New York City Administrative Code imposes liability on a building owner, right, for the fact that because it owns the property that abuts the public sidewalk. So if the accident occurs on a public sidewalk, again, it can't be part of the leased premises. It's not owned by the lessor. It's owned by the city. The sidewalk law imposes liability on the owner because it owns not the sidewalk, because it owns the property that abuts the sidewalk. So as long as the condition abuts the portion of the premises that is leased to the named insured, the court has found coverage. Again, irrespective of the fact that it's not part of the leased premises, irrespective of the fact that it was the lessor that was required to maintain the premises. Again, what's important to remember, I think, is that this policy doesn't just insure the tenant, it insures the landlord, right? The landlord is an additional insured.
Thank you.
So
You'll have time on rebuttal.
Good afternoon, Your Honor. Madam Chief Justice, I believe.
Oh, if only.
your
But thank you, you
of
just
the
gave me
appellate
a
division,
promotion.
I think your questions have made my case perhaps better than I could make it myself. But I stand here for the simple proposition that in AI transfers or attempted AI transfers, circumstances do matter. And that's exactly what Justice Adams found below. I doff my cap to my friend, Mr. Gershwire, who's had a long record of success. But if you look at the cases that Mr. Gershwire cites, all of the cases stand for the proposition that circumstances do matter. For example, he relies heavily on the technology decision, which was decided in the Southern District on removal. But in that decision, the court made plain that the underpinning to its decision was the fact that here the lease provided the tenant a license to use the entire building, including the basement, and did in fact use the basement.
And here, not only did the tenant not have use of the basement, but the store that he occupied had no access to this cellar. So he had no way of making any use or benefit out of that cellar space. It was completely separate from the leased premises as defined in the contract.
Exactly so. And I would call the court's attention to pages 961 and 962 of the record, in which, in the notice to admit, Mr. Gershwire conceded the basement is not included in Rio's lease, and Rio had no obligation to maintain the basement nor the cellar doors, which opened to the staircase leading to the basement. Further, and this is critical, In the notice to admit, Mr. Gershwire stated at page 962 of the record, at the time of Mr. Sime's accident, October 15th, 2018, Rio had no access to the basement as another AKJR tenant, Rock Fashion Boutique, had exclusive use and control over the basement. What is also in the record, and what seems to be ignored, is that at page 808 of the record, there is a third-party complaint against Rock Fashions, which had the use of the basement
So
at the time of the
that
accident.
any insurance provided here would be double dipping on the actual party who should be liable under the leases of this building and the space.
Well, exactly. If there's any insurer who issued an AI certificate, it should be the AI certificate running from the lessor of the premises that actually had access and use of the basement.
So you would agree that there was a trip hazard, a structural trip hazard in the front of the store?
On the side
I
of
would
the
not,
store.
Then just bear with me, then language as liability arising out of the ownership, maintenance, and use of that part of the premises leased. The front of the store is leased, and the ownership of the premises is by the landlord. So in that case, you would argue, would you agree that maybe the landlord would be entitled to be an additional insured?
well, Your Honor, before I address the exact premise of your question, I urge the court to look at the photographs. Google images are wonderful, and the Google images at page 450, 452, and 454 of the record show the condition.
No, I understand the
which
lip
is
around the
around the corner on Elder Street.
Counsel, I understand that. I'm just picking up a little bit. To make this provision make sense, it would have to be the landlord owning a portion of the actual premises lease to the store owner, correct? Which would be, and that's why I picked the front of the store.
Yes, Your Honor, but if, to take your question to the next level, if
And make it a
tenant, a
quick next level, because you're out of time. Okay, please.
may I finish the response?
Quickly, please.
Okay, if the tenant was asked to lease a premises with a raised cellar bulkhead directly in front of the entrance to his store, he would say, why should I lease this unless you repair it? And to take it further, if he went to his insurance agent and his insurance agent said, well, listen, this is an obvious tripping hazard right in front of your premises. Why should I issue an AI certificate if you are not going to remedy that or get the landlord to remedy it?
Thank you.
So thank you, Your Honor.
Thank you.
Your Honors, sorry.
You have a minute.
Thanks, Judge. So all of these issues that are being raised in terms of the fact that the tenant here didn't have use of the basement, or that the issue might be different if the condition were in front of the store, those all have to do with the question of whether this arises out of the use of the leased premises. So if the additional insured provision only covered liability arising out of the use of the premises, all of these issues would be relevant. But it doesn't.
No, the issue is whether the seller is a part of the leased premises. That's the issue.
Again, Judge, I disagree based on based
well-
on this court's precedents, which is that it makes no difference if the accident happened.
Except that all of these courts' precedent didn't have the facts that we have here. They didn't.
In terms of the
They had access to the space at issue. They had use of the space at issue, and here, this plaintiff did not. But we have your record, and we will review it before deciding.
Thank you, Judge.
you. People versus Jose Rivera. You may proceed.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Jose Rivera. May it please the court. This was a buy and bust prosecution that pitted the credibility of Mr. Rivera against the buy and bust arrest team. A number of errors prevented Mr. Rivera's counsel from effectively impeaching the officers. First, the court's rulings on impeachment and the prosecutor's withheld disclosures prevented the defense from
Well,
cross-examining.
you say they withheld disclosures, but the people say they were unaware of that third civil suit prior to the trial, so I don't know that that would qualify as withhold if you didn't know about it.
Yes, I understand the court's question, and the withheld disclosure, I recognize may be an issue for a higher court than this one. So I would like to address the
other issue.
Well, with respect to the other two,
Yes.
though, didn't there have to be a finding of fact adverse to Mr. Rivera, to Detective Rivera, or some finding about his credibility to be useful to defendant at this trial?
Okay, so there were two different there were two areas of questioning, two lawsuits that the defense was not allowed to ask about, and they're subtly different.
Do you want to talk about the other officer in the presence of Mr. Rivera? Is that what you want to talk about first?
That's what I want to start with, and I'm happy to talk about the McElwain complaint also. So the Vargas complaint, it was alleged that Ramos was part of an arrest team that falsely arrested and beat a person falsely accusing him of selling drugs, just like this case. And during the course of that beating, it was alleged that one of the officers involved in the beating explained why he was being beaten, that he was...
No, we read the case.
Okay.
Yeah.
And to be clear, that other officer who made the statement was specifically named, so we know that it wasn't this officer.
That's correct.
Right.
But it did explain Officer Ramos's actions. Ramos was identified as someone, Ramos was identified as someone who participated in the beating while that other officer made that statement, Mejia made that statement. It's not a case where it's a group of unnamed officers, a list on the cover of a complaint with 12 different officers plus a number of John Does. This is a case where Mr. Detective Ramos was specifically identified in the text of the complaint.
And the judge, as I recall from the record, permitted questions about the incident, but not the statement. Why is that error, since that statement, one, was not alleged to have been made by him, is clearly hearsay? I don't understand what the problem is, since counsel was permitted to ask questions concerning the issues of his participation in an unwarranted beating.
Well, the reason is that the probative value of the cross-examination would have been immensely helped if he was able to...
And how would that examination not have been impermissible in creating a trial within a trial about an issue having nothing to do with the trial?
Well, it would have been a single question.
Which is the other balance, right?
It
that
is.
You don't allow evidence about something having nothing to do with the case that dangers the proceedings from falling into a trial within a trial of having nothing to do with the issues before the trier of fact.
Well,
How would that not have been the case had the court allowed not just the facts which they allowed, but this statement about some other officer?
Because it would have been a single additional question. I mean, we had a trial that spanned days, and the impeachment questioning as it stood with what was permitted by the court was 2 pages. What is that, 2 or 3 minutes? We're asking that...
But that's not the issue, right? The issue is whether there is inappropriate prejudice on either side. So...
And there is inappropriate prejudice when the defense lawyer doesn't have the tools to get at the truth. And just merely asking May I continue?
Yes.
Merely asking a single question, did you falsely arrest Mr. Vargas, is a far cry from allowing the defense lawyer to probe the specific factual allegations that were made.
How is the fact that defense counsel chose to question it that way? I don't believe that the court mandated that that was the only question. That was the question defense counsel chose to ask and limited there. How does that fall upon the people or the court?
Well, that was the only, I mean, it could have been phrased differently, and perhaps it wasn't even phrased exactly like that.
Right.
But without giving the defense lawyer the tools, the specific facts, and probing the specific facts as they happened, it was answered with a no, and move on, counselor. I mean,
But that would have been the same, even if the additional question had been asked. The officer could have said, no, that's not true, and that would have been it. How does that equal sufficient basis to overturn?
well, we can't assume for the purposes of prejudice that he would
You
have.
just
that
said,
would have
he
given
said
that
no.
answer.
So I should assume that he would say, oh, yeah, you're right. He would fall on the sword with one additional question?
Well, under
He would have probably answered the same way he did to the other
he
ones,
may have.
right?
He may have, but defense counsel should have been given an opportunity, and that's always the case when we're limiting, when we're talking about limited cross-examination. We don't know the answer that they would have given. Obviously, my contention is he would have told the truth and admitted it, but maybe he wouldn't have.
Okay. You may proceed.
May it please the court, Milan Shachanda for the people. The court here made balanced, and I would say even generous, rulings in accordance with settled law with respect to the scope of permissible cross-examination of Detective Ramos, who played only a marginal, relatively minor role in this narcotics transaction. I'll start with the Vargas lawsuit.
Any member of a undercover buy and bust is an essential member of the team.
I understand, but in terms of identifying, or in terms of his guilt and establishing that guilt, it was the two undercover officers who actually participated in that transaction and who were not impeached similarly with any prior bad acts. And also, with respect to the buy money that was recovered, there was also another detective who witnessed it and also was not similarly impeached or had similar lawsuits. But I'll turn to the Vargas lawsuit. The court issued an expansive ruling on allegations that I would actually say were more general in nature. All of these allegations did say individually and collectively 4 officers, and then didn't specify what each of them did actually. But the court, nevertheless, in an abundance of caution, as the court noted, allowed questioning. And I'd like to note that the questioning was not just limited to, did you falsely arrest? There was, were there injuries? Did it result your assault arrest in a broken nose? Did you deny and deprive the defendant of medical treatment? There was further questioning, so it wasn't just one question and done. What the court properly did is not allow questioning about a specific allegation. And I want to note, looking at the complaint, that is the only specific allegation made against any officer in the entire, I think, 50-paragraph complaint. So that was specific to Mejia, and the court properly, it could not be attributed to Ramos. And unless there are questions that could go on the McElwain complaint, it's a denial of summary judgment. It's not an adverse finding. And unless there are other questions.
What about the fact that the third complaint was not disclosed to the defendant?
Okay, Your Honor, there's no evidence in the record that, and defendant doesn't allege, that the people knew about this complaint. And I think this case is on pretty all fours with Garrett, in which there was also an allegation that the people had to go scour for a federal complaint that was publicly available, and the people did not. And the Court of Appeals held that the people do not commit a Brady violation by not knowing about a complaint, a federal civil rights complaint against a specific
So willful
officer.
blindness is okay. If I don't look and I don't know, I don't have to tell.
But that's
so I
not-
just don't look.
We don't know that because in this case, obviously, the prosecution found the Vargas complaint and the McElwain complaint. I
don't know that. Maybe the officers told the prosecutor. But it seems to me if the prosecutor knows that there are already two, I would dot my I's and cross my T's and look.
And again, Your Honor,
So that I don't commit a Brady violation. I don't rest on somebody who has already had two complaints filed against them.
well, first, Your Honor, the Court of Appeals says it's not a Brady violation.
I understand that.
And
I understand that. But the question is the prosecutor doing everything they can to fulfill their obligation, right? The fact that there's a case that says you don't have to jump through cartwheels doesn't mean you can put on blinders when you have somebody who has already committed at least arguably two.
And Your Honor, if you look at the colloquy in which the prosecutor says, I'm looking further because my search has come up with something, the Vargas thing does not seem to apply to, there was another officer, Vasquez, I think, and I need to do further research. So there is record evidence that she's saying, I'm looking, and what I'm looking, I'm not even sure if the Ramos is a Daniel Ramos, it says John Ramos, I need to reconcile that. So there is record evidence that she is doing some research. What there isn't record evidence of, and that's why it's unexplained in the record, is why this particular lawsuit was not revealed. But as the court says, it's not incumbent on the prosecutor to scour every, and we don't know what she did not do, but we do know on the record that there were attempts to reconcile the misnaming of the officers and to find out more about Officer Vasquez as well.
Thank you.
Thank you.
Counsel?
Just addressing the last point first. The Cintron lawsuit was filed on NICEF. We're talking about scouring courthouses for records. Go to the website and look for the name Ramos. That would have found it here. Addressing the McElwain complaint, the Court of Appeals in Smith said that you can't cross-examine about the fact of the filing of a lawsuit, because the fact that a lawsuit has been commenced, like the fact of an arrest, has little or no probative value to the officer's credibility. This was a far cry from just the filing of a complaint. A federal judge wrote a 19-page opinion denying summary judgment, raising detailed questions about the discrepancies in the pleadings and the honesty of the officers.
But was there anything that prevented you, or I don't mean you personally, but the defense from utilizing that decision in examining the officer?
Absolutely. The court said that they weren't permitted to examine the officer beyond just the allegations of the complaint.
Okay.
There were discrepancies, for example, between what the officers said in their pretrial depositions.
Counsel, just to put a point on that, the finder of fact is the jury, and they could say he was perfectly credible. Detective Ramos was perfectly credible, right? This is a preliminary, it was a summary judgment motion. So in other words, there's something to go to trial on, but the finder of fact could be 180 degrees in their assessment of Ramos's.
They could have, but you cannot say about a complaint that survives summary judgment that it has no probative value whatsoever as to the officer's credibility, and that's what Smith said about.
There's no, but in a denial of a summary judgment motion, there's no affirmative finding.
There is.
It's just there's an issue of fact.
Right.
So how does that become something that you can utilize to impeach on credibility? The judge left it for the issue for the jury to decide. There was no determination.
Agree, Your Honor, although it ultimately was settled for $260,000.
That is irrelevant, and you know
understand that. But I'm addressing the seriousness of these allegations. And what Smith said is you can't ask about the lawsuit if you just have the mere filing of a lawsuit, because it has no It has no probative value. Where a lawsuit has survived summary judgment, just allow a question, and a lawsuit has been filed against you in that matter. Isn't that correct? Allow that question. It's not the mere filing of a potentially frivolous lawsuit. It's a lawsuit that survived summary judgment where a court wrote a 19-page opinion outlining the discrepancies in the defendant's case.
Thank you.
Thank you.
Gurnie, Goldman versus Sila Management. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court, my name is Mitchell Geller, and I'm appearing here for the plaintiff's appellants. The primary issue on this appeal is whether Saul Goldman Investments, LLC, what I'm going to refer to as SGI.
There's the threshold issue of mootness, though. Do you want to address that?
Oh, I don't believe, yes, I will address that immediately. They brought up this issue of mootness, but since the decision dismissing SGI as a party, SGI has been involved in all of the matters in the action since that point in time. And I'm going to refer, I hope that the court will take judicial notice of docket number 423, which is a November 22, 24 conference in the case, where Mr. Tata is one of the lawyers representing SGI, and he specifically says he wants to be involved in depositions in the case. And he says
Whoa,
to
this
Justice
is way
Crane,
dehors the record,
Yeah.
counsel. I don't know.
I'm sorry, this was after the
It is
briefs were
dehors
submitted.
the record.
What about law?
And we
You know,
should not be hearing any argument on anything that is not a part of the record.
what about a case that supports your position?
No, what I'm saying is that our argument is that they have chartered their own course and been involved, our brief says this, they have been involved in all the proceedings in the action since they were dismissed.
And again, I'm telling you that if you are making arguments that are dehors the record, it is inappropriate.
Okay.
So stop.
What I'm saying,
Okay?
What I was saying, Your Honor, is we refer to a case called Wimbledon Financial Master that specifically says that the appellate division, First Department, permits the claim that was dismissed with leave to replead to be evaluated on appeal because, quote, the parties have chartered their own course by proceeding as if the instant appeal is not rendered moot. That's exactly what the First Department said in that case, and that's exactly what has happened in this case.
Okay, so let's understand on this record, the motion court dismissed the first, fourth, and fifth causes of action, the first being breach of contract. You're also seeking an inspection of the book and records, and you're seeking an accounting.
Yes.
Correct? And at the very least, would be your position that the fourth and fifth causes of action stand alone, separate from the breach, because SGI was not a party to the operating agreement, correct?
I'm sorry, what was that, Your Honor?
I'm sorry, I went too fast. It would be your position at the very least that you should be able to get the right to inspect the books and records and get an accounting, even though you were not part of the operating agreement, to be able to sustain a claim for breach of contract, correct?
Yes, but except that is not our primary claim. The primary claim is the breach of contract of the put right. That is by far the primary claim, and that is why we are here. We have a put right that is part of an amended and restated agreement in 2008. That agreement took about 4 years to negotiate. And the agreement specifically says...
But then, counsel, how do you get around Wythe-Perry?
I'm sorry, what was that?
How do you get around the
Very
case of
simply,
Wythe-Perry?
because in Wythe-Perry, it specifically says that New York's LLC law, quote, does not dictate that non-signatory LLCs are always bound by the terms of their operating agreements, close quote, which means that Wythe-Perry recognizes that there are circumstances where a non-signatory LLC is bound to the terms of the operating agreement, and here an operating agreement that is signed by all of SGI's members, which expressly requires SGI to, quote, redeem, close quote, the members' interest at fair market value, and further provides that, quote, the company will redeem the affected interest at a closing. That is a specific instance where the language of the SGI operating agreement specifically obligates SGI to take actions. By the way, that is only one of the obligations in the SGI operating agreement. They've been operating as if they were bound to the SGI operating agreement since 2008. But the language, and I would actually point to Your Honor's Justice Mansonet's opinion in LNYC law, which specifically says, operating agreements executed by all the members of an LLC, quote, will be enforced in accordance with those same principles concerning the parties' freedom to contract. Now, Section 1.02 of the SGI operating agreement specifically states, quote, that's at R887, the members hereby agree that from and after the effective date, the company shall be governed by the terms and conditions of this agreement. That language is express language that the members have agreed that SGI is bound to the operating agreement. No question about it.
It sounds like that it says that the members are bound to each other under that agreement, not that SGI is.
No, Your Honors, from the LNYC case, freedom of contract means that the members who are the real parties in interest of an LLC decide what are the obligations. All of the form contracts of LLCs specifically do not have the LLC as an entity, yet the LLC is always bound. Now, Justice Crane relied on one case that is wrongly decided. All the other cases that we have pointed to, the Chung case, where specifically it was an operating agreement, the defendants argued that, oh no, they cannot be liable because they're not a signatory, and the judge dismissed the motion to dismiss. There's even the TKS case where they're not a signatory and they are, the claim proceeds on the put right option, okay? But the fact is, most importantly, LLCs are governed by the members. And the fact that the entity is not a signatory is what happens all the time. And in fact, I think that this case has far-reaching implications because the fact is, if you hold that a non-signatory LLC is not bound to substantive obligations in an operating agreement, I really do believe that it has far-reaching implications. Now,
Thank you. You're out of time. You'll have time on rebuttal. I've let you go for at least 2 minutes.
The Supreme Court's dismissal of the contract claims against Sila Goldman Investments, LLC, which I'll refer to as SGI or the company, should be affirmed. Some state legislatures outside of New York have enacted the Uniform LLC Act, and that act says that even if a company does not sign its LLC agreement by statutory mandate, it is nonetheless bound. But in Wythe, the First Department noted that New York's legislature has decided not to enact a statute like that. And instead, as Wythe made clear, what happens in New York is ordinary contract principles apply. And what that means is the plaintiffs here have the burden to demonstrate that the contract includes language that manifests an intent for the company to be bound. And they can't carry their burden. Not only can they not carry their burden, it's worse for them because the contract here includes two features, two statements that in combination makes it crystal clear that the intent was that the company will not be bound. And every New York State case that has addressed the situation here has said that when one of those two features are present, the company is not bound. First, the very first paragraph of the LLC agreement here says the parties to this agreement are listed. They're identified in Exhibit A, and the company is excluded from that list. That's JRA 875 and 947. Those pieces of language combined with the fact that the company did not sign the agreement, either of those is enough to demonstrate the intention that the company is not bound by the agreement. Here we have both, and the cases are cited at pages 19 through 21 of our brief.
If the plaintiffs want to seek remedies against the other members, which they do so for not complying with the put right obligations in terms of the appropriate appraisals for the redemption, they have that right and remedy in the amended complaint, correct?
Exactly, Your Honor. They have it in the amended complaint. They're litigating it at this moment. So they don't believe that they are without recourse.
Right, and you wouldn't disagree that under these circumstances, or you may disagree that there could be an obligation under the limited liability law, the LLC law, to have the right to be able to inspect the books and records.
I do not disagree that there is a statutory right to books and records. What I will say is that the claim for books and records that they're making is completely duplicative of the one that they're making right now against the members and the managers, and they're also getting plenary discovery in the action below. So they have no issue with whether or not they're going to be getting books and records. And I'll also add that we heard that supposedly this case...
Notwithstanding any discovery process, you don't disagree then with my colleague's question that under LLC law, section 1102, they would be entitled to books and records?
They would be entitled to books and records, and the question is whether that demand is properly made on the managers of the LLC or the LLC itself. Will they get books and records? Yes, they're going to get books and records.
What is the difference? Please explain to me.
Yeah, I think the difference is on whom is liability potentially imposed for a breach of any such statute. I think that's the only difference. It's not, is the obligation to provide it different? It's just whose responsibility is it?
And so the option, according to you, was what?
You can have an order against managers saying you must turn over the books and records.
So managers of the company?
Correct, who are responsible
How is
for
that
running
different
the company.
from, if managers work for the company and you order the company, it seems to me to be a distinction without a difference.
The result is the same. It's just who bears liability if it doesn't happen. That's the only difference.
Well, it seems to me that the manager works for the company, so if the manager doesn't produce, it would be the company that's liable because the manager works for the company, no? Or is the cart before the horse?
Your Honor, I will not dispute what you're saying because the effect is the same either way. They're going to get it. And I just want to point out that one of the main thrusts of the argument that we heard on the question whether the company is bound is supposedly this case is different because here the LLC agreement says the company shall do this. It must do that. There are commands directed at the company. That does not distinguish this case in any way. And we know that because in all the cases that have said that the company is not bound, all of those cases had LLC agreements that says the company must and shall. In the Wythe case,
I'm going to ask you to...
I'll wrap up. I'll just give you the case sites.
Okay.
Wythe, if you look at our brief, page 35, note 11, and page 1082 of the decision, you'll see that the LLC agreement said that Wythe, the company shall make payments and distributions to members. ApparelNet by Justice Singh at pages 3 through 8. LNYC case at Westlaw pages 1, 2, and 7. And the Crunk case at pages 782 and 798. All of those cases required the company. It said the company shall make payments to members. And in all of those, the cases granted the motion to dismiss, and the company was held not to be a party to the agreement, either because the contract said who the parties are to the agreement and the company was excluded, or the company did not sign it. Here we have both. The Chung decision...
I got you. Thank you. Good try, though. You got 1 minute on rebuttal.
If I could have 2 minutes, Your Honor.
You got 1 minute on
Number
rebuttal.
one, section 8.06 on page 920 specifically says each Class A member will have the right at its sole election to cause the company to redeem. Just to put this all in context, and we have arguments about under the NCMI case and the Wallace case, which is that a court can interpret an agreement to prohibit an absurd result or to render an agreement where a provision is rendered unenforceable. Here we're talking about, to put this absurd result into context, our put right, just for this 2022, because we have it every 5 years with the company, is literally approximately $120 million for a 5% interest. They acted throughout consistently that they were bound. They started the whole put right process. They hired the appraiser for $850,000. They even sent us draft promissory notes and a redemption agreement prepared by Sullivan and Cromwell in connection with a purported closing. That clearly shows that the company believes that they're bound. But to prohibit the absurd result is that this court can and should interpret the agreement to say that SGI is bound because of the express language of the agreement and because of the intent of the parties. Because if you do not do this, literally you are rendering the entire put rights provision null and void.
Thank you.
And that's under the interpretation provision.
Thank you so much. Harrum versus Montefiore. It's all right. You can stay back there. All right. Counsel, you may proceed.
Good afternoon. May it please the court. My name is Gail Kellner. I'm appearing for Plaintiff Kyle Harrum. It is our contention that the court below should have granted our motion for summary judgment under labor law, section 240 sub 1. And I would just like to address the two issues that I think have come up with respect to it. The defendants have all seemed to jump on the specious argument that because this large piece of sheet metal, which was about 5 feet by 8 feet and very sharp, was blowing in the wind, that was not a gravity-related incident.
So I believe their argument is that because it blew in the wind horizontally, it did not have the forces of gravity, which I, for the life of me, cannot understand that argument, but it is what it is. You go ahead.
I agree with you, Your Honor, but it will address it nonetheless. What this is the descent of a large object that should have been secured for the undertaking, which was to remove it from a penthouse equipment shed to the 29th floor of the Montefiore building. It should have been secured and the descent should have been controlled. And that is why this incident occurred. It was, and I would certainly refer the court to page 1255 of the record, which shows a piece of sheet metal, which may not be the actual one, but the same dimensions. This large, sharp piece was attached by one small hole to one corner of this 5 by 8 piece of sheet metal. It was a 300-foot rope, and that was the only device being used to lower this piece of metal, and it was uncontrolled, it was unsecured, and because it was unsecured and uncontrolled, it was certainly subject to whatever forces of nature could occur. Had it been properly secured, in accordance with Runner versus New York Stock Exchange and all of the other line of cases that have dictated the manner in which an object should be secured for its descent, this incident would not have occurred. The proximate cause of this accident was a blatant violation of Labor Law 240 in the manner in which this piece of metal was lowered in an unsecured fashion, not the forces of the wind. And I would certainly refer this court to Runner, as well as this court's own decisions in cases such as Flores and Mayorkas, in which you have addressed the fact that an object being lowered in this matter must be secured. So this was a wild event, and it was proximately caused by a violation of the labor law. The second argument that has been raised by at least one defendant is that there is a conflicting recounting of what occurred by the plaintiff. That is not true. Plaintiff testified exactly as to the manner in which this incident occurred, which was as this piece of metal was being lowered from the penthouse to the roof, it moved and it sliced his entire arm open. His employer testified, Mr. Jellison, later in the discovery process.
Who wasn't there at the time of the accident, so all of his observations are hearsay.
He testified that he was told by someone else that this is what occurred. He testified that there may have been accident reports and there may have been documents. Nothing was ever exchanged, ever. The only thing was his
And none of the witnesses, none of the employees who were at the site of this accident at the time that this accident occurred were produced during discovery.
There were
Not one of them.
Not one, Your Honor. The only one that testified as to the manner in which it occurred was the plaintiff, but they have somehow tried to say that this was his testimony. There is nothing other than this hearsay accounting by Mr. Jellison that in any way conflicts with the plaintiff's sworn testimony. No accident reports, no witnesses, nothing, not a scintilla of evidence. And the case law is such that hearsay testimony such as this alone is completely insufficient to in any way cast any doubt on the veracity of the plaintiffs or create a conflict as to his testimony.
Would you like to save the rest of your time for rebuttal?
I will, Your Honor. Thank you.
All right. Who's going to come up first for the defendants?
I will, Your Honor.
And you are
Nicholas Calabria with the law firm of Omni Demers McManus. I represent the respondent appellant, Montefiore Hospital, on this matter.
That's what I needed to know what time to put on the clock.
Most important thing.
You got it. Go ahead.
I believe the record was clear that Montefiore should have been granted summary judgment and dismissal of the labor law section 200 claim. And they should
Because
have
they didn't control the means and method, only ESS, correct?
Correct. All they did was rent their roof to one entity in the case, SBA. SBA then subleased it to Flow TV. Flow TV hired KMB to be the general contractor, who then hired ESS, the plaintiff's employer. We had nothing to do with that chain of events. All we did was rent it. We had nothing to do with the sublease, and we had nothing to do whatsoever with the construction project. We didn't have anyone up there. Both plaintiff and his foreman testified we had nothing to do with it.
So that the only exposure you have is under the 240 sub 1 strict liability as an owner.
Correct. And I have, I believe, established contractual indemnity against both my tenant and the subtenant. Both the lease and sublease contained indemnity agreements whereby they were to indemnify Montefiore Hospital and their affiliates with the tenant for any claim resulting from or arising out of the use or occupancy of the leased premises. And I would consider this a use of the premises. The indemnification by the subtenant, they were to indemnify Montefiore Hospital for the results of any removal of equipment on the roof. So I believe both were established. We were not negligent in any way. We should be granted full contractual indemnity. Thank you, Your Honor.
Thank you. Okay, who's up next? Which defendant is coming up next?
Good afternoon. My name is Diane Toner. I represent the SBA defendants. So the main issue with the SBA defendants is whether they are a proper labor law defendant. So we maintain...
If they are a proper what?
Labor law defendant. So whether they had the authority to supervise and control the work that was being done. We maintain that they did not. They were not in contract with KMB. They were not in contract with ESS. They had no hiring or firing capability. They were not paying these contractors. They did not discuss...
But you were an agent of the owner. And as an agent of the owner under our case law, you remain in the chain of liability for labor law 240 sub 1, certainly.
Well, what does it mean to be an agent? The dispositive question is whether the entity has the right to exercise supervision over safety measures.
The dispositive issue is whether you serve as entity for the owner. And if you are the owner as a strict liability defendant, you would fall under the same umbrella. So that really, at the end of the day, is the issue.
Well, we cited cases in our brief in which you have an entity which is subleasing from the owner and subletting to another entity.
But you do more than just sublet, right? You are the go-between the owner. You communicate to the company that does the removal, exactly what items on the roof are to be removed, et cetera, right?
Well, the items that are to be removed, that's dictated actually by the building owner, and we communicate. So we do. The basic facts are not in dispute. So we coordinated a walkthrough. We communicated what the owner's specifications were.
And all of that is as the agent of the owner, right? You
With all
got
the-
paid in order to communicate the desires of Montefiore to whoever else was let up on that roof with equipment.
Well, having the position of being the communicator is not the same as having the authority.
I think what my colleague was trying to raise is based on the actual lease you had with Montefiore. You actually had the right, it granted you the right to install and maintain radio antennas and systems and their pertinent structure. That's in your document with the owner. Moreover, on this record, you had the right to determine the location of the equipment. You had the right to determine, and you had the ability to have access needed for flow. In other words, you were part of this process, as an agent in a sense, even stronger than an agent. You had a contractual right and obligations in this context. So while you may not have been directly involved in the means and methods of what took place here, and it was ESS ultimately, and that doesn't appear to be disputed on this record, that it was all ESS that controlled the means and method. But on this record, it sounds like you're a statutory dependent.
Well, with all due respect, I think ultimately you have to question whether the plaintiff or his supervisors or KMB would have listened to anyone from SBA if SBA had walked in and
We're
said,
supposed to decide that on this record as a matter of law?
there is no evidence.
Really? On this record, we're supposed to decide the question you just posed, whether the other parties would listen to your guys.
Well, we have to.
That is a factual question if I've ever heard one.
We have testimony from KMB, from ESS, from plaintiff that SBA was not involved in this project. So there is nothing that pins any supervisional authority on SBA.
Okay, thank you. Who's next? Don't all jump up at once. And you are for?
I am Briggs Johnson for the Flow defendants.
Okay.
Good afternoon, Your Honors. C. Briggs Johnson. I just said it. I'll say it again. So on Labor Law 200, like we already established, ESS directed, controlled, supervised the work. They provided the tools and equipment. Labor Law 200 negligence is gone. I have contractual indemnity from KMB because there's a mutual indemnity clause. There's plenty of case law that says those are legal and valid, right? And my indemnity promise is even broader because I'm supposed to indemnify KMB if I'm found strictly liable under the labor law. He's supposed to indemnify me if I'm strictly liable under the labor law. But KMB is also supposed to indemnify me for the negligence of its subcontractors, ESS, right? So his promise
Don't
is
we need to, I mean, we can have a contingent order at this time, but
Yes.
ESS's negligence has not been established yet as a matter of law.
No, that would be a question of fact. And so they would be ESS in the foreman, and also plaintiff's negligence, if any, would be imputed to the employer for the purposes of the indemnity promise.
So as my colleague just said,
Yes.
any holding would be contingent upon a finding of negligence of ESS.
Correct. It would be a conditional order of indemnity at best. And then we also haven't, our agreement with SBA also required SBA to indemnify us for any acts or negligence that caused the accident. And there's testimony from Flo, as Justice Mansonet pointed out, that said SBA told them when to remove the equipment, which equipment to remove, how to remove it, So we should be entitled from contractual indemnity under that agreement too. I just want to touch briefly on 240. I know, Your Honor, you said that it was hearsay regarding how the accident happened.
From Jellison? He wasn't even there.
No,
of
I
course
understand.
it's hearsay.
So he came 2 hours later, and he said plaintiff told him.
It's still, hearsay is
Yes.
an out-of-court statement
Right.
made for the truth of the matter asserted.
Correct. But there's exceptions to the hearsay rule, which would be an omission
what
by a
if-
party. There's exceptions to the hearsay rule.
And what was the admission?
The plaintiff said that the sheet metal was leaning on the wall at the time of the accident, that it wasn't
And
hanging
even
above.
if it was leaning on the wall
Correct.
and a wind picked it up and it sliced almost his arm off to the bone,
Correct.
How would that not still fall under 240?
I would say-
If it's not being held down so that that accident doesn't happen.
I would say it would be an issue of fact under the de minimis doctrine, as I put in my brief, because it was
De
5 to 10
minimis
pounds.
what?
The de minimis doctrine.
Okay.
Thank you.
All right, thank you. KMB?
Good afternoon. My name is David Schultz with Baron McTiernan and Moore. We represent KMB Design. With the limited time I have, I want to focus on that mutual indemnification provision, because the effect of it, unlike what Flow TV contends, which seems to sort of ring up, let's count the number of ways in which the indemnification provision can be triggered, it's not the right way to look at it. An indemnification provision is either triggered or it's not. If it's triggered, indemnification is owed. If it's not triggered, it is not owed. And here, the provisions are identical. KMB indemnifies Flow TV for, I want to get the right words, for strict liability imposed by law. And by the same token, Flow TV indemnifies KMB for strict liability imposed by law. Presuming, and on this record, I think this would be the right decision, the Labor Law 200 and Common Law negligence claims are dismissed against all the defendants. What is left is a Labor Law 240 claim and a Labor Law 241-6 claim. If plaintiff prevails on either one of those, KMB and Flow will each be held strictly liable, imposed by law. In that situation, both provisions are triggered. Each indemnifies the other. They essentially cancel each other out.
Okay.
Right? And if I have time, I just would
Still have a few?
on the Labor Law 240 claim, where you
Okay.
said that you cannot see how
No.
gravity. One of the tenets the Court of Appeals has said is that for Labor Law 240 to apply, there must be the direct application of gravity. upon-
The pendulum is gravity.
I agree. It is being lowered. However, the force on the object that caused it to strike Mr. Harrum was not gravity. It was the wind that blew it laterally.
Counsel, we've already held that in a case called Rivera, which I was on last year, we found that a pendulum, which is what this amounts to, is a force of gravity.
I would
And
agree.
I had a case maybe not even 2 months ago with this exact argument of horizontal wind not counting. And we dismissed that argument out of course. So no cigar on this argument.
With respect to the pendulum, I would agree 100%. Pendulum, the force of a pendulum.
What is the safety device that was utilized on this sheet that should have prevented this accident?
That is not the issue.
Oh, that is the issue. The issue is what safety device is provided to a worker to prevent the kind of accidents that are envisioned by 240 sub 1. And here, they put a rope on a single side of this piece of, this sheet of metal that was so dangerous that it cut this man's arm down to the bone.
I am not diminishing the seriousness of the accident.
Okay, so there was no safety device. That one rope obviously did not work.
To answer your question, with respect to the application of gravity, the rope was a half-inch thick, double nylon, 300-foot rope with a carabiner that could hold 10,000 pounds.
And it didn't work.
It kept it from falling.
It did not keep it from swaying and cutting this man.
Wait, correct.
I'm not going to debate this with you. You've had your argument time. Thank you, counsel. Next.
Good afternoon, Your Honors. Karen Ondrovic, and I represent ESS. The issues against us are really pretty limited, as you know. The first issue, I think, as we've already discussed, is that our argument is any finding of indemnity as a matter of law, which is what has been sought, is premature. Because in order for them to get an indemnity finding against ESS, they have to establish negligence. And that has not happened. In fact, there's not even been any efforts to give this court any evidence in KMB's brief that we were negligent. So our contention is that there is not yet any evidence before the court.
But we have some evidence. Mr. Gomez is the only person who directed all of the work here, and he allowed this sheet to come off of that building with just one rope.
Yes, Your Honor.
So that to me is evidence.
But it hasn't been established.
I agree with you on that.
Okay, so that is really my point. The second issue is almost the same issue as Mr. Schultz just raised. We have the identical indemnity provisions in our contract. And in that case, they basically call for the same result. In this case, K&B, as they've argued, should not be liable for negligence or 200. So their liability is for strict liability. So their indemnity provision specifically says that they have to indemnify ESS if they are found strictly liable.
And that's correlative, so you also have to do the same?
Yes. So in my case...
So they cancel each other out just the way...
Well, that is the argument. In my case, it's slightly different because I cannot be held strictly liable because I'm the employer. But the indemnity provision doesn't say it has to be both or it matters that one is strict and one is negligence. In this case, I would owe them indemnity if I'm found to be
But that's not an issue we have to decide here.
Well, it's not unless this court finds what also I know K&B is arguing, that they in essence are awash and neither party owes any party indemnity because of the mutually exclusive indemnity agreements. That is the argument. So we are asking that you find that indemnity is not owed at all because the two provisions basically wash each other out.
All right.
Thank you.
Okay, thank you. And you have 2 minutes on rebuttal.
I have no desire to hold the court captive with my rebuttal time if it's not necessary.
Thank you so much. We
Other
will
than-
take that with 100.
Other than to make one small statement, which will
Okay.
not take up the 2 minutes. The account of Mr. Jellison, as it is totally unsubstantiated, should not be considered in any event. It was total hearsay with no evidence backing it up whatsoever. So I would ask it be discounted, and I thank the court.
All right, E.W. Howell versus Hill International.
May it please the court? I wanted to start by talking about the scope of a implied covenant of good faith and fair dealing claim when it's based on frustration of the arbitration or the ADR process, or in this case, a dispute resolution process.
Okay.
So Hill argues certainly that our claim is redundant, and it's not. They cite to the court, to the Parlux decision, but as we explained in our briefing, Parlux requires not, would say that the claim is redundant only if it's based on the same damages and the same conduct as a breach of contract claim, and that's certainly not the case here. You do have to have both those components for it to be redundant. The other argument they're making is that Whitestone does not reach claims other than that the arbitration process had not begun. And we disagree with that. A good faith and fair dealing claim is going to be guided by longstanding New York law. I think Whitestone's an application case, but I think the court could look at for guidance, and we've cited it in our briefing. It's certainly in our reply brief at page 14, the Court of Appeals decision in 511 West. And 511 West is going to stand for the proposition that an implied covenant claim applies to anything really that's done to frustrate or hinder or diminish or disrupt a contracting party from enjoying the fruits of the contract. So in this instance, our implied covenant claim reaches not just when the claims were submitted finally by Hill to the dispute resolution process under Article 29 of the contract, but also reaches the other conduct that it did in frustration of our right to get a fair determination through that dispute resolution process. I want to spend just a minute talking about their suggestion, or not their suggestion, but the basis of their motion for summary judgment, which was that our claim wasn't viable any longer after CUNY's executive director issued that May 4th, 2023 letter. That letter was under the terms of that two-phase dispute resolution process in Article 29. That letter represented the executive director's initial written decision, or his written decision. But if you look at the structure of Article 29, what you see is that that written decision and our claims are currently pending plenary review in front of CUNY's vice chancellor. So he could wipe the whole thing away. We don't really know. So really the summary judgment motion is...
It doesn't affect your claim that the ADR process was infected by Hill not participating properly and placing your claims before CUNY properly, correct?
It does not affect those, correct. It does not affect our claims about that. I mean, we've got a problem with the summary judgment being premature, but setting that aside for a moment, because tomorrow, for example, the vice chancellor could issue that final written decision. Their argument, and we don't know what it's going to say.
Right.
So, I mean, all roads may lead to a remand or an abatement. I don't know how the court wants to handle that. It sort of depends on what the vice chancellor does in that final written determination. But the argument that Hill made to, and the trial court was apparently persuaded by it, was that the Article 29 decision by CUNY meant that we had no compensable damages. There was no way that we could be harmed.
Because you weren't given an opportunity to present the Carino exceptions.
That's correct. We weren't given that opportunity. There were other things that we didn't get as well. We've outlined them in the brief, beyond just sort of waiting the 4 years and that, you know, everybody was gone who had knew anything about the project. But they didn't pass along to us. Hill did not pass along to us everything that they were giving to CUNY, and I mean that's a problem under the contract between CUCIF and Hill. Hill is the one who's charged with the responsibilities to keep us informed and keep us in the loop. So we did not have an opportunity to sort of meaningfully participate in a resolution of the claims through that Article 29 process.
All right,
I'll
you'll
reserve
have
for
time on
rebuttal.
rebuttal.
Good afternoon, Evan Blaker from Cohen Saglius for Hill International. The central issue in this case relates to this Article 29 alternative dispute resolution process. And that article has been before this court before. Howell, in this case, has challenged that provision before. They had filed in earlier cases.
Yeah, but that was only whether Hill's role as a 3A lien trustee, 3A trustee was valid or not. That was the only issue in that initial appeal.
I'm sorry, I didn't hear you, Judge.
I'm sorry. That our first case had a narrow issue before our court, which was whether Hill could serve as a 3A trustee or not, and that was it.
Correct,
But we didn't have to go on and reach the ADR process after that.
The only point was that Howell has challenged this provision. They don't like this provision, and I get it. If I was a contractor doing business with the City of New York, I might not like this provision either, but they are bound by it. This is their contract. They're bound by Article 29. And we have to look at Article 29, because Article 29, because really what we're talking about is this dispute within the scope of Article 29, i.e., does this dispute have to go through the alternative dispute resolution process? And in fact, it does. And in fact, this court has already determined that under the Whitestone case. So the scope of Article 29 essentially says that in relation to the agreement between Hill and Howell, all items, all controversies, everything goes through Article 29. The issue was brought before this court in Whitestone. And what this court found in Whitestone is maybe one exception to that. The scope is broad, but because in this case, the construction manager is the gatekeeper,
If the gatekeeper doesn't fulfill and forward the claim on to CUNY, you have to have relief. And so what Whitestone found very clearly was it relates to the mechanism of fulfilling, or excuse me, forwarding the claim on. And Howell knew that because that's the claim that they pled in this case. The only claim that has been pled in this case in Howell's complaint is, Hill, you failed to submit the claim to CUNY. You're sitting on it. Whitestone says you can't do that.
Isn't it more nuanced than that? I mean, isn't it also saying that the application of the no damages for delay provision in the contract has exceptions to it, and those exceptions were not presented by Hill to CUNY?
Well, if the answer to that is that's what Article 29 is all about, right? So Article 29 says that the claim gets submitted to CUNY. CUNY makes its ruling. Whether Hill submitted everything, nothing, the right things, the wrong things, analyzed it right, analyzed it wrong, what Whitestone says, that's subject to Article 29. You have to appeal under Article 29 if you don't like the decision of the executive director of CUNY in this case, and Howell knows that because that's exactly what they did. Once they got the decision, they appealed it.
Yeah, but any competent lawyer is going to pursue the administrative appeal as well as this appeal, as well as the plenary case that's in front of us. I mean, you don't want to foreclose one of your options. You get in trouble for that, you know.
Well, again, Whitestone is very narrow.
Yeah, but Whitestone's holding is clear that as to whether the ADR process contemplated a party required to do their obligation to make the ADR meaningful, and Hill did not. I mean, you frustrated the whole process. Does that make sense to force them to go through a process that you frustrated that will never get a remedy? That's why the Whitestone holding is to allow for a plenary action.
That's not what Whitestone says.
That's exactly what Whitestone says.
Whitestone says frustrating access. Access. We didn't frustrate access because they got their access, they got their ruling, they got their decision. If the argument
the gatekeeper could provide to CUNY fraudulent documents, but because it allowed for access, there'd be no cognizable claim?
There's no cognizable claim. Because
that is insane.
Because
okay, that just, you know, it's these kind of arguments, okay, that inure to the detriment of our system. We can play games. The contract says I have to do this, but I'm going to ignore that, and the court is just going to let me get away with that. That's what you just argued.
No, Judge, what I'm arguing is there is relief, but it's not...
What's the relief?
An Article 78 claim that could be brought, and they have the right to bring that claim. They have the right to...
An Article 78 claim to say, I didn't even get to be heard because this guy who was supposed to submit all of the documents to be assessed didn't do so. So what are we talking about?
So if that claim is allowed, every contractor under this article, under this type of contract, will have this very claim. Every contractor will be able to make an argument and file a lawsuit.
Because every contractor has somebody submitting claims fraudulently. Is that what you're saying?
Well, Judge, there's no...
But this is what, look, we've got to deal with the facts on this case, not the all of the other cases that have an Article 29 component. I'm dealing with this case.
So
tell me why, with someone who doesn't do what they're supposed to do for 10 years, right?
If that's the facts, then you're blocking the access. We know that access was not blocked here because we got a decision. Factually, what happened here in this case...
Counsel, your red light is on, so you don't have time to factually what happened here is all over again. Sorry. If you'd like to make one final point, I will give you 30 seconds. But you're not going to do what happened here was. We're not doing that.
The only thing I was going to say, Judge, is that when this case was filed, when this complaint was filed, there was no decision from CUNY. During the pendency of the case, CUNY made their decision, and it was a substantive decision. It was a substantive decision on the merits, and CUNY found that there was no basis for the claim. This contractor now has the relief that they're entitled to under Article 29, and they've availed themselves of that.
Thank you.
I'll be brief. His argument is a technical one about whether access was blocked completely or not, and I think that this is the type of case that the implied covenant is tailor-made for. And if the court doesn't have any other questions, I'll conclude.
Thank you, and I hope you get home in time. Fineberg versus 72nd Tenants Corp. Please take your cup with you. Thank you. You may proceed.
Good afternoon, Your Honors. May it please the court. First of all, I would like to apologize regarding the misunderstanding on my behalf regarding the timing. This is my first appeal. This is my first appeal.
It's okay. You go right ahead.
Great. Thank you so much. Your Honor, this is Aparna Pujar from Naplish Kalnik representing the plaintiff's appellants. Your Honor, there are four main issues in this brief, four more main arguments, but the most decisive point, which I'm going to speak about first, is regarding whether the plaintiff recognized the cause of her accident. Your Honor, the facts of this case are such that the plaintiff, my client, is 82 years old, and she went to her eye doctor. When she went to her eye doctor, in fact—
Dilated her. We know the facts.
Yes, Your Honor, and also she had a cataract surgery a few days earlier, and the doctor also observed that she had clouding in one of her eyes. This was completely ignored by the lower court, Your Honors. And then she steps out of the office. It's only half
But the problem, the court's decision was primarily based on the fact that your client in their EBT is not able to state what caused her to fall. She points to nothing in her deposition about why she fell, right? In fact, she says, I don't really know why I fell, right? And then later, after the plaintiff's counsel gets an expert and the expert submits their report, she now changes her statements and adds a lot of statements that mirror almost exactly the expert's affidavit. We call that a feigned issue of fact. So tell me why it isn't that.
Your Honor, it is not. I agree with you that she did not say any of that during her testimony. Your Honor, these are the facts of the case. I'm not trying to gain sympathy from the court, but she was 84 years old at the time of the deposition, Your Honor. And when the accident happened—
Unfortunately, we don't have some kind of exception for people of advanced age, okay? So that is not going to be an excuse that carries you very far. So I don't see how we can get past the fact that on the plaintiff's case, she provides no basis for the proximate cause of the accident.
Your Honor, even if that is the case, it is a credibility issue, Your Honor. I mean, this cannot be decided by the summary judgment court. It has to be decided by the jury. It has to be a fact before the jury. I agree wholeheartedly that she did not say anything during her deposition, although she did.
So then what does the jury decide? She has to have put forth evidence that there was some condition created either by the doctor or the building owner that caused her to fall. There is no evidence in the record of that. So there is nothing for a jury to decide, respectfully.
Your Honor, there is the expert report, and she did during her deposition point out to the fact that she was getting out of the doctor's office, and that is when the accident happened. She testified to the fact that she exited the office, she used her right hand, the door comes inside the doctor's office, she stepped out, and then may I continue, Your Honor?
You have 20 seconds.
Yes, Your Honor, so it is a credibility issue, Your Honor, and that should be gone, that should be before the jury. And secondly, Your Honor, even otherwise too, there is a lot of circumstantial evidence that supports the facts. We have the
Okay,
photos.
I'm gonna let you give me all those arguments on rebuttal. I wanna hear from the other side right now.
Thank you.
Okay? You may proceed.
May it please the court, Elizabeth Oren for Respondent 72nd Tenants Corporation, Brown Harris Stevens Residential Management LLC, and Michael A. Nath. The Supreme Court properly dismissed plaintiff appellant's claims against the defendant respondents in this negligence case, and this court should affirm. It's black letter law in New York that if a plaintiff cannot articulate or identify the defect that caused her fall, then defendants are entitled to summary judgment, and that's what we have here.
Counsel, what if any defect is there on this step?
There is no defect. Our expert, whose affidavit has been submitted in our summary judgment motion, as well as in our reply to this appeal, went to the step, inspected it. He wrote an extensive affidavit showing how none of the building codes applied, explained why, cited to statutes, and then went through a detailed analysis of his measurements and found that there was no defect, and this was a safe step.
Was there any evidence contrary to that submitted?
No, Your Honor. And I'm going to rest at this time.
Thank you. All right.
Good afternoon. My name is Evie Kazansky. I represent Dr. Coles. So I join with my colleague with respect to that this case should be affirmed. There are some other issues that the court has not brought up that are in my brief. And if she,
Well, Dr. Cole
if she
had
can't get
nothing
over
to
the
do
first
with
one,
with the construction of the step outside his.
we're not responsible for the, irrespective of that. And the secondary issue is the court should be reminded that she was able to get out and was able to close the door. So any issues with respect to coming out of the space is speculative, and any duties to warn or put up any warnings would have been non-existent because she was able to get out safely and stand on the step before an incident occurred. Thank you.
Thank you. Okay, you have 1 minute.
Your Honors, there is a defect in this step. The defect is that there is a light right in between the step, and then it has only one hand railing, and you are right outside a doctor's office. Although it does not
For how
violate
many years? For how many years prior to this incident did this plaintiff visit this doctor at this office and walk into the office, past this step, and exited the office, also using the step?
Your Honor, for about 15 years, once every year, Your Honor. But Your Honor, when you're going to a location, not everybody observes the specific aspect of a location. She does not remember, or she does not know whether there's one step or a few steps. You don't really remember the specific aspects. She goes to the doctor, she exits, she goes only once a year there. She's been going there for 15 years, but just once a year. And
When she was deposed, did she actually use the word that she misstepped? Or, misstepped?
Your Honor, she used the word that she lost her balance.
Lost her balance.
Yeah, so
So she didn't say that she slipped on something or that she tripped on anything, she lost her balance.
She said she lost her balance. She did not, Your Honor, she did not say that she slipped or tripped. In fact, she said, I don't know what happened.
Well, she said, I did not. She did remember that she did not slip or trip. So it wasn't like there was a substance on the stairs that made her fall. In any case, we're out of time. Thank you so much. Have a good day.
Okay.
Thank you. Zimmerman versus Serreta Davis Stevenson. You may proceed.
Good afternoon, Your Honors. May it please the Court, Tatiana Medina Rodriguez, Zegner, Elman, and Cross, counsel for the appellant. The respondent was not entitled to relief. To move for summary judgment in lieu of the complaint, it has to be based upon a judgment, and here there was no valid judgment. For 3 reasons, we argue that the 2012 judgment was void and unenforceable and therefore should have been disregarded by the court. The first reason being that in the matrimonial action, the court lacked jurisdiction to consider the respondent's submission of the judgment since it was 1 month after the action was discontinued. So in essence,
Did we leave open the question about what the validity of the judgment in the Solomon case, or has it been decided?
it has not been decided, Your Honor. So if we look back at specifically the language,
I'm looking at it. But at the end of the decision,
from this court, you're saying?
yeah, of the Solomon case, so the
Yes.
one that's at 118 AD 3rd, 613, we say we have considered respondents' contentions in support of vacatur of the Zimmerman judgment and an award of attorney's fees and find them unavailing. So it sounds like we said, no, we're not going to vacate the Zimmerman judgment.
And I was on that case.
Yes, I did see that, Your Honor, and I I am very cognizant of that as well. And I do understand that. So at the end of that, it does say, as Your Honor, you quote, that in support of vacatur, the Zimmerman judgment, find them unavailing. But prior to that, right above that, the court also does say, and I'm just going to quote so I'm not misrepresenting anything, it says, respondents contend that the Zimmerman judgment is also unenforceable, which we're arguing that it's unenforceable.
But we were quoting what the respondents were arguing, not what we held.
And I understand that, but then right after in the next sentence, it says, we need not decide this issue. And therefore, we argue that by saying we need not decide the issue with respect to enforceability, that there was no decision yet rendered. And also, our interpretation follows the same thing from Judge Lubis in 2016 in the protective order, because specifically...
Well, the issue really is enforcing the judgment. That's what's going on here. The issue is they wanted to be able to force the sale of the home to be able to satisfy the judgment. And because they reconciled and you have a non-debtor living in the home, they couldn't use that mechanism. That's what this is all about. It doesn't necessarily vitiate the judgment.
Right, so there is one component back then, which was the enforcement of the sale, but also the 2012 judgment itself that we believe is being referenced with respect to the Zimmerman judgment. That 2012 judgment, the court still said we need not decide these issues with respect to whether the strict requirements when it comes to matrimonial law were actually followed. And it's very important for us, we would like to just reference to the court, even going back to the 2007 order, because in the 2007 order, the court specifically said, plaintiff moving for an order fixing the amount of legal fees. By fixing the amount of legal fees, there was no application with respects to a security interest in the property. It was just an application as to the counsel fees that should be awarded. But it wasn't an application as to there being a security interest in the property. And that's also further supported later on page 82, as the court is saying in the 2007 order, also Judge Lubis, stating the above sum to be held in escrow, and I quote, from the proceeds of the sale. Subsequently in 2011, when the court's once again granting another motion, it says, shall be converted to a judgment, directs the respondent to submit a judgment that is pursuant to the above quoted language, where it says shall continue to be secured by the proceeds of any sale of the property. So back in 2007 and in 2011, the application being with respects to just the counsel legal fees, there was no application as to there being a security interest, which is very important when it comes to matrimonial law, based on the relationship between our client and counsel. It was...
You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon. If it pleases this court, I am Michael Zimmerman. I am the respondent. I represented Elaine Sarita Davis Stevenson in a divorce that took place in the early 2000s. I wanted to withdraw as counsel. Some of this is in the record. I was asked to stay on the case. I did. I was assured that efforts would be made because I wanted off because I wasn't getting paid. We are now 20 years later. I still have not been paid. Challenges to the orders have been made over and over again. Dispersions against my character have been made over and over again in all of these papers. I obtained this judge.
It seems to be that they concede that you have a charging lien against them. The question is just whether you can proceed against the property. You want to speak to that?
That's not an issue before the court right now. However, I actually believe that I should be entitled to go against the property. Otherwise, it will literally be waited out until the expiration of this judgment. I actually waited a very long time, and when approached by Solomon Holding, I joined him to be able to get paid. And the expectation was actually not that the sale would ultimately take place, but simply that it would be refinanced. This is there's a tremendous amount of equity. But
Mr. Zimmerman, you would agree that from the time you got your earlier judgment, all the passage of time really addressed enforcement, correct?
Well,
it doesn't vitiate the judgment.
Yes, yes. Well, no, they also challenged the validity of the judgment.
I understand. And so you would agree that Solomon Holding v. Stevenson, as was pointed out by my colleague, pretty much made it clear that we held that you were entitled to the judgment.
Exactly.
And that's why you moved for summary judgment in lieu of a complaint now.
Exactly.
Correct?
And I was going to say there are 4 reasons to grant it. It's the existence of an actual judgment, which is really undisputed. The defendant was a judgment debtor that's undisputed. The original judgment was docketed at least 9 years prior, undisputed. And the original judgment remains partially or completely unpaid, undisputed.
The 2013 decision of Lobis
Yes.
and our decision in Solomon started by recognizing that the order of the Supreme Court in August of 2013, which to the extent appealable, denied respondents' motion for renewal of the petition for an order directing the sale of their home to satisfy 2 unrelated judgments. Not 1, 2. And we continue to have this issue come up again and again and again. There's a judgment. We've said so. So I don't understand why we continue to come back. But I'm sure you're in the same place.
Yes, Your Honor. Thank you, Your Honor.
Your Honor, I understand what you're saying.
I'm sure you do. I don't think your clients do. The fact that your clients decided not to divorce and got back together doesn't mean that this gentleman didn't earn his legal fees and shouldn't be paid.
And we are not disputing that.
Apparently, somebody is, because he still hasn't been paid.
There have been attempts to try to pay the respondent and also to try to enter into a settlement agreements. But regardless of that, it's important to note that our client previously was pro se. I'm not trying to get into any sympathy or anything regarding that, but what I'm trying to explain is that our client has conceded to the debt, acknowledges the debt that started with the $33,000. But what we are currently arguing is that when it comes to the 2012 judgment, which was rendered after the action was discontinued, it was void, and also—
But no court has held that. Our decision did not hold that. And it appears that no one's paying attention to that.
And we do understand that there has been no specific holding in terms of vacating because it's void, but it is still null and void since it was after it was
No, it's
discontinued.
not. It is not. There is a decision that says there's a valid judgment. So I don't understand your statement, counsel.
So if I may very briefly, Your Honor, our position is that given that the time of when it was
You said this argument already, so I don't need to hear it again with all due respect. I don't mean to be disrespectful in any way, but you are just restating the same argument, okay? But we've heard you, and we will decide again.
Thank you, Your Honor.
(154) East 62nd Street versus Norus Realty. You may proceed.
Good afternoon, Your Honors. Scott Mullen for 154. I thank you in advance for your patience. It's a long afternoon. I listened to all of it.
Thank you.
I,
You had to sit here.
I appreciate that. Let me get right to the heart of the issue. The court basically did what I believe Justice Higgett and Justice Moulton warned they should not be doing, and that is rewriting a contract that had been negotiated by parties represented by counsel and imposing what a trial judge, in hindsight, views as a fair result. This wasn't a typical 881 proceeding where the court has broad discretion to award whatever they think is fair and reasonable. This wasn't a blank slate. There was a contract by the parties, and it could not have terminated. It wasn't logical. It could not have. There was a permanent underpinning of our client's property, which was done as a trespass with no license, no consent at all. And in addition, damage had been done to a wall at the time. There were other claims for damage, and only then was there a settlement agreement afterwards. And the parties actually contemplated the fact that this neighbor, who had a history of having all types of problems, Your Honor, Justice Manson-Daniels talked about 10 years without complying with a contract. Well, how about 7 years for a family with 3 children living adjacent to a construction site? And the court got certain things right, trial court got certain things right, but they got certain things wrong that are hard to understand. They tried to blame it on COVID. That was false. The record was clear. First of all, this was an expansion of a dental facility which had an exemption, and we've addressed it in our brief, as a medical facility that was uncompleted, and therefore it was viewed as essential construction, but they had 4 months before the toll came into place, even if it was non-essential. And even if it was non-essential, that ended back in 2020. We're sitting in 2025.
Counsel, would we be here today if the trial court had set the fee, the license fee, pursuant to the 881 proceeding at a higher level? In other words, if he'd gone to what you had in the contract.
Well, basically,
I mean, would that have settled the matter?
we still had a claim for specific performance.
Well, they have to anchor the trellis. They have to do
There was
something.
work that had to be done. There was a 4-story wall that when our client looks out their window, there's an unfinished, unconstructed wall that's high out their window, and they admitted, it's interesting, Normanus admitted, yes, we have to complete the wall. Yes, we have to put in the anchors for the trellis, which would help mitigate the problem. So you have all the parties saying, well, we need the underpinning to continue. We need the anchors. We need the flashing. We need the waterproofing. And yet the trial judge said, I think it was terminated. And then the judge apparently realized, well, wait a minute. If it's terminated, you have all these other provisions. This wasn't a first license agreement the way the court characterized it. It was a settlement agreement. The license was only part of the settlement agreement. There were damage claims. There were releases. There were all types of obligations in there. And what the court did, it basically took somebody who, as Judge Manson-Daniels said, didn't perform for 7 years and said, you know what, it's a lot of money. we're going to reward them by reducing the amounts that the parties had agreed to, parties
So
with counsel.
if I understand your argument, you're saying that the license agreement never terminated, therefore you're entitled to the weekly fees that you would have been able to collect under
Yes,
the license
paragraph,
agreement.
that's correct, because under paragraph 16, it applied until the work was completed. It's not unreasonable to say if you create a construction site that you compensate a family that has been, by the way, the settlement agreement specifically admitted, Norus admitted that they knew our client wanted to renovate their own backyard. They want to do a glass structure there, and for 7 years, and by the way, what are one of the benefits of having a brownstone in Manhattan? You have a private backyard in a very dense borough, and trial court even said they've been deprived, the trial court said they've been deprived of the use of their own terrace, their own backyard,
But weren't you entitled to that fee only if the license was extended because the license ended by its own terms after 6 months?
By its own...
Or if the chimney was not constructed, whichever came first?
It's interesting, Judge, because the settlement agreement contemplated the chimney and the vertical elevation might not get done. It specifically contemplated this could be modified. The key to ending it was perform, complete the work. Paragraph 16...
Did the contracts, did the license say that? Did it say that?
Yes.
It said that.
The contract had a provision that said Norus reserves the right to modify its plan to do the vertical elevation. And paragraph 16, which is not an extension paragraph, that I think the court was kind of muddled the thing together, paragraph 16, the heading is remedies. And in paragraph 16, it said until completed. Well, 7 years is a pretty, I don't know what the outer limit is of a reasonable period of time, but I know 7 years is not.
Thank you. You'll have time on rebuttal.
Thank you for your patience.
Good afternoon, Your Honors. Josh Oberman for the respondent from Windell's Marks. Your Honor, 154 is talking about everything besides what this agreement says. And as far as sympathy for 154, they are very wealthy and extremely litigious.
That doesn't matter.
Well, Your Honor, but
That does not matter.
okay, Your Honor. Let me go into the content of the agreement. The termination clause, the lower court held that there is a termination clause per Article 1.2b, and it says, and I'm quoting, the agreement shall terminate on the earlier of 1, the completion of the license work, and then it does say, and 2, 6 months after the commencement date. The lower court looks at that agreement and says, okay, well, obviously...
It seems to me that those two provisions don't actually... I can see an impossibility there, right? Because you can start and not finish within 6 months. So those two terms kind of contradict each other, no?
Your Honor, what the court found in a very reasoned, methodical opinion is that if you want to interpret the contract holistically, which we have to, it says, while 6 months have elapsed since the first access contract began on October 2019, the license work has not yet been completed. And if we interpret the first access agreement...
It didn't say or, it said and.
It did say and, Your Honor, but they...
So and doesn't mean or.
Your Honor...
So it's not you complete or 6 months elapse and then you're out. It said and.
Yes, Your Honor, but
right?
if you read the clause...
So I am addressing your argument.
Please, Your Honor.
How does completion and 6 months after not be a potential contradiction, as it clearly is here?
Your Honor, the court did, it is a contradiction, Your Honor, you're right. And the court held that. They said, and this is a quote, interpreting that access agreement to terminate after both the completion and 6 months from the commencement date would render meaningless the introductory clause stating the contract would terminate upon the earlier of the two conditions. Conditions means just that. Something has to happen in order for those things to occur. And then when you come to Article 16.1, which is a termination clause, it says in plain American notwithstanding the foregoing, if the license work isn't completed by the termination date, the license term shall be extended, conditioned upon Normanus making the payments to 154 as required below. And we didn't make any payments. That's not contested.
Did you take down your scaffolding?
We never put it up, Your Honor. We never accessed their property. That's why, Your Honor, if it looks
Well, you did access their property because you put underpinnings underneath their building. So you did access their
Your Honor, you're absolutely right. However, that was done, obviously my client's a civilian. He hired an architect.
Civilian.
The architect was rogue.
Okay.
He was fired, and we also paid for that, Your Honor. This settlement agreement had 3 different obligations. 1, we paid for the underpinning, and we paid for property damage. 2, we had to put up anchors for a trellis. We did that already. It's moot. It's been done. It was done about a month ago. We're still arguing about it. And we paid for the underpinning. So these are great facts.
How about the pest control?
Your Honor, I don't know if that...
You were supposed to pay for pest control from the excavation site. When you excavate a site, the neighboring properties usually end up with a lot of rodents going into their property. And these parties have indicated such. So in light of the license agreement, including that, was that done?
Your Honor, it was done those 6 months. We terminated that access.
I'm sorry, is there still a hole in the ground next to their property?
No, Your Honor, there isn't. Under the second access agreement, which we entered into about a year ago now, that is, I believe that is a provision, and we are providing it.
Okay.
Could you address the variance between the access fee under the settlement agreement and the fee as it was set in the Appellate 881 proceeding?
Yes, Your Honor. In that settlement agreement, there were penalties, as there are often in access agreements, for taking an extended time on the neighbor's property. We did not, in that first access agreement, ever enter onto their property, save for the underpinning, which was already resolved. So the first access agreement said, okay, it's going to be an access fee of X. Then, for the first 6 months, then we're going to $1,500 a week if you're still working on our property. Then, after 6 months after that, you're going up to $3,000 a week. That's a typical structure in a normal standard access agreement. But we didn't do that. We terminated the agreement. We came up with a new agreement at an above market fee at $4,500 a month. I do these all the time. It's very typical. The church next door is getting the same thing.
They don't have to look at you outside of their bedroom window.
Your Honor, I understand. Right? This is Manhattan.
Okay,
there's a lot
that's different, okay? And we're not going to pretend like it's not.
Your Honor, that's fine. I agree with that. However, you have to interpret this agreement holistically. We have 2 options. We can end after 6 months, or, and I know they said end, but the court is saying it's obvious there's 2 options, and there's a clear way to end this. If we don't pay, we have to get off. And that's why, Your Honor, if we continued to be on their property, we had to pay more. But we never even entered their property.
All right. Thank you.
Thank you, Your Honors.
I've had the experience, unfortunately, and I know each of you have had the experience, where somebody makes representations to the court that are just contradicted by the record or outside the record. Your Honor made the statement that you should not be talking about things outside the record. I have current pictures, which I would have loved to show you, of an unfinished wall with debris, but counsel says, oh no, all the work was done a month ago, when the record is closed. We would contest that, so I'm not going to let that go unanswered. That's number one. Number two, this is a site which was so dangerous that an intruder, it's not contradicted, an intoxicated intruder entered a child's bedroom because of a lack of security accessed from the unfinished construction site, uncontradicted in the record. Next paragraph, under their theory, which is, I think, absurd, they cite the extension paragraph and say, if we choose not to continue paying, then the agreement terminates. Okay, so we have a half-finished construction site, and under that theory, there's no obligation to clean it up and finish and remove everything. It's an absurd interpretation. And if you look at paragraph 16, which we say is the operative provision, it says, number one, it uses the words beyond the termination date. It addressed what occurs beyond the termination date, and it says they have to repair, clean up, and restoration is completed. It spells out how it ends. So the idea under their theory, they could put up, and by the way, the trial judge himself said that the site plan, by the way, he compared the two site plans from the first agreement and the current agreement. And the trial judge said, if you look at the two site plans, even though he stopped the two higher stories that he wanted to add, the impact on 154 was the same. Essentially
Safety
the same.
measures that would have to be employed for your client's property do not change.
That's right, and he even added that there had to be a pipe scaffolding, which, by the way, scaffolding, is there. So the idea that they could drag their feet, blame COVID when the record shows they had multiple DOB violations. They had litigation with their contractor, litigation with their engineer, litigation with their architect, and they make it sound like they worked it out with the church really easily. There was an 881 proceeding. They had to sue to get a resolution. And the trial judge pointed out there's a vast difference between a family with 3 children living next to a construction site and a church which is occupied only during limited hours. So the idea of comparing apples and oranges. Thank you for your patience. I wish everybody a happy and healthy New Year.
No, absolutely not. Don't even ask. People v. Ashanti Holmes. You may proceed.
Good afternoon. I'm Danielle Bernstein from the Legal Aid Society on behalf of Mr. Ashanti Holmes. Your Honors, the issue in this case is an informational disadvantage that made it virtually impossible for Mr. Holmes to litigate his criminal prosecution. Now, that manifested in 2 contexts, as the court knows, the motion to controvert and the Dunaway motion, and I'd like to begin with the
We talk about the waiver, though, as a threshold matter.
Sure, Your Honor. The appeal waiver in this case can't withstand the fatal flaw that the plea court indicated that Mr. Holmes would not be able to present any issues on appeal since he signed an appeal waiver. That's a fatal flaw in this court's precedent and in the Court of Appeals. So turning back to the merits, if I may. As to the motion to controvert, at the outset, I want to note that the Court of Appeals has held in Castillo that protective orders are only permissible in, quote, extraordinary circumstances, right? Because we're talking about a defendant's constitutional due process rights. We have to balance that against this issue. And in this case, the issue in court never said why it was issuing a protective order. And that in and of itself is the issue here, Your Honors, because in exercising the extraordinary power to obviate Mr. Holmes' constitutional due process rights, it owed him the bare bones explanation as to why. It could have made a reference to the confidential informant's safety, ongoing investigations, the current investigation. It didn't even bother. It didn't even say that the prosecution had offered, quote, good cause. And that is at odds with Castillo, where the lower court said why it was issuing the order. So in this case, that is an abuse of discretion because, how could this court even review whether there was an abuse if the court's not giving this court its reasoning to review on appeal? And so that's the issue as to the protective order. And that in turn led to this problem with the actual underlying materials that were so heavily redacted as to be useless to Mr. Holmes in his defense. We have 75 answers from a confidential informant whittled down to 14, less than 19% of what the person said. All of those answers are yes or yeah answers, which were in response in turn to questions that were redacted. I mean, that's a useless document to a defendant in defending against his criminal prosecution. And certainly at a minimum, because this court has held in analogous instances that review is merited under those circumstances, we do ask that the court at a minimum review it in camera as the prosecution's consented to. Well, that's great news, Your Honor. Well, I still nonetheless urge the court to allow us to see that as well for the reasons that I've said. And if I may, if the court doesn't have any questions about the motion to controvert, turn to the Dunaway motion. Right ahead. Great. So the issues here are heavily interrelated, but I do want to make clear why they're distinct to the court. The issue with the Dunaway hearing, even though it turns on the probable cause question, is about the court's basis for denying that motion. In this case, the court said that Mr. Holmes didn't allege factual allegations to support the motion, and that's why the court denied it. But that isn't a permissible basis for denying a Dunaway motion in circumstances where the defendant doesn't have access to any of that information.
He is the person inside the apartment. He has all the information he needs at the time of the execution of the warrant to make the necessary factual allegation in order to get a Dunaway hearing. So I reject that argument outright.
Respectfully,
he is in the apartment. He can say, the apartment isn't mine, they didn't find it there, whatever.
But the issue, Your Honor, is whether there was probable cause to support the search warrant, and Mr. Holmes never had access to that. It's not what happened once they were in the apartment. It was the basis for the no-knock warrant that led them to enter the apartment. That's the distinction, Your Honor. Everything that happened after that is irrelevant to the factual allegations he needs to allege in the Dunaway motion.
That the CI was one of select group of people who had been to the subject premises on numerous prior occasions during the days prior to the execution of the warrant, and that the parties were known to one another. So your client was not without any information.
Well, first of all, Your Honor, I'm not sure what section you're quoting from, but if those are from documents that he received after he filed the motion, he wouldn't have had access to that specific statement. But regardless, Your Honor, the issue as to the probable cause problem, and this kind of brings us back to the search warrant issue under the motion to controvert, is what the people say in their conclusory statement about that is one thing. What Mr. Holmes needs to know is the credibility of the person who's making those statements to the people, right?
That's what the in-camera inspection was for, right? And the court did that here and was satisfied.
It did that after it denied the Dunaway motion, Your Honor. So that actually has no bearing on its decision to deny the Dunaway motion, which it did before it did that in-camera
Wouldn't
review.
the court have looked at the warrant application prior to the Dunaway? How could, you have to have an arrest to make a request for a Dunaway. So
He
the
was
search
arrested.
warrant application would have happened first.
Yes, Your Honor, but the court that decided the Dunaway motion didn't have access to the search warrant. That was a different court that issued the search warrant. So that's the material that the defense and prosecution were fighting over. The court did its in-camera review of those materials after it denied the Dunaway motion. So that's the issue, Your Honor. That's why it has no bearing on the Dunaway motion.
And what would have prevented the court from, had they found a basis, from changing their decision? Nothing would have prevented the court, after looking at the warrant information, to change its finding if they thought that was warranted.
So two answers to that, if I may, Your Honor.
Yes,
So
I asked the question, yes.
That brings us back to the motion to controvert issue, which is, you know, the issue that Mr. Holmes is once again at an informational disadvantage to actually litigate that question that you're
Right.
raising. But on the actual merits of the decision as to the Dunaway motion, I appreciate what you're saying is it comes out in the wash, but the decision by the court to say, you didn't allege facts and that's why I'm denying it, that doesn't come out in the wash. Because that is the court setting a precedent that if this court upholds it, I think is really damaging to criminal defendants to say, you don't have this information, doesn't matter. And that, I mean, the stakes of that, Your Honor, are a person's ability to withstand the full power
I
of the
know,
state.
but your solution is to give these warrant applications, which oftentimes are provided by people who would be in danger if that information came out. But you'll have time on rebuttal to
Then
address
say they're in
my
danger,
statement.
Your Honor.
Okay? You may proceed.
Good afternoon. May it please the court. Elliot Hamilton for the Office of Darcel D. Clark. The oral colloquy, the waiver of the right to appeal, explicitly stated that it was a separate and distinct right. The defendant is a multiple-time convicted felon where he pled guilty in every single one of his criminal convictions under the totality of circumstances test under People v. Thomas.
Did the court adequately state that there were some claims that could survive an appeal waiver?
It was covered by the written waiver, and
The
even
written waiver said that, but did the judge?
I think, well, given that, I would say the judge did not, but given the totality of the circumstances regarding this defendant being a multiple-time convicted felon.
Did the judge ensure on the record that the defendant had reviewed the written appeal waiver with counsel?
Yes, he did, and that was on pages 9 and 10 of the plea minutes, where the defendant, again, multiple-time convicted felon, been through the process before, indicated with the plea court that he did review the contents of the written waiver, which did spell out the interest of justice claims that do survive the waiver of the right to appeal on the record. And based on the totality of the circumstances there, it completely forecloses the Dunaway claim and the search warrant claim on this appeal. If there are any questions, we ask that you affirm.
Thank you.
Thank you.
Counsel, you have 1 minute.
Sure. Well, the Court of Appeals has held that a written waiver cannot replace an oral colloquy, so I think that ends that. But I just want to be really clear in this last minute with the court about how small an ask this is relative to the stakes. I appreciate, again, that the court has already reviewed the materials, which we are grateful for, and I just want to be clear that the ask here is just that the lower court show us its homework, right? Because that's really a small ask relative to the ability of a defendant to one, exercise their constitutional due process rights in general, which is sort of the fundamental tenet of what we're all talking about here, and two, be able to protect themselves from a case that, but for this search warrant, wouldn't exist, right? I mean, the search warrant is the whole ballgame here. And so for Mr. Holmes to exist with this informational disadvantage against this protected right, the lower court has to be incredibly thorough and explain to the defendant why it made that ruling, and the court didn't do that here. And then again, as to the Dunaway issue, you know, I really am glad that we got to clarify that the court actually did not follow the procedure that the court is indicating is necessary here, because once again, even if it comes out in the wash as to the actual probable cause issue with the warrant, the court does have to do this the right way. And that does matter, not just for Mr. Holmes, but for all defendants. Thank you.
Thank you. Silva versus Baker Botts. Last but not least. You may proceed.
Thank you, Your Honor. Brendan Quigley for the appellant, Baker Botts. The court below should have dismissed the breach of fiduciary duty claim and the unjust enrichment claim. Those claims arose out of the same facts as the legal malpractice claim, which was barred as a result of Mr. Silver's plea and conviction in the Southern District of New York. And those claims don't seek distinct damages from the barred legal malpractice claim. A plain reading of the complaint showed there was one representation of Mr. Silver by Baker Botts, and it was intertwined from the get-go with issues relating to the Department of Justice and the Securities and Exchange Commission. And that's paragraph 5 of the complaint, appendix 14. It says, defendant did in fact represent plaintiff and act as plaintiff's attorney between 2015.
Counsel, again, this is a pleading motion. What about the allegations concerning the influence of Mr. Hu, his business partner and co-defendant, by Baker Botts? In other words, Baker Botts was trying to control Mr. Hu in a way that was helpful to the attorneys at Baker Botts, but not to the plaintiff in this case, not to Mr. Silver.
Your Honor, again, I think that's all as evidenced by the fact that Mr. Hu, and this is in the record also pled guilty and was the co-defendant. That's all.
Yeah, he doesn't have you don't have a malpractice case, but what about the case? What we're talking about here are the other claims.
The breach of fiduciary duty claim, Your Honor? Right.
Right.
The breach of fiduciary duty claim and the unjust enrichment claim are both, again, the only fiduciary duty alleged is the attorney-client relationship. If you look at complaint paragraph 6, once the retainer was signed as such, a legal and financial fiduciary relationship was created. And then complaint 55, by virtue of the attorney-client relationship, defendant owed a fiduciary duty to plaintiff. So the only fiduciary duty here arose from the attorney-client relationship, and therefore it's duplicative of the legal malpractice claim. This isn't a case where there's some separate relationship or separate fiduciary duty. And the same thing with the unjust enrichment claim. The basis of the parties' relationship in this case was the attorney-client relationship. And if you look at the unjust enrichment claim in the charging language, in paragraph 59 of the complaint, that expressly refers to the retainer agreement. It says, by virtue of the retainer agreement, the extremely poor and deficient representation rendered by defendant, talks about misappropriation of monies, talks about excessive fees, all tied up in this representation that flowed into Mr. Silver's criminal conviction, and therefore those claims are duplicative and should have been dismissed along with the legal malpractice claim. If there are no further questions, I'll reserve my remaining time. Thank you.
Got it.
Good afternoon. You saved the best for last. I was always in the back of the classroom anyway when I was growing up. I think what the defendant would like the court to believe is that when there are numerous claims and one claim of many is dismissed, that they all need to be dismissed. Facts are facts. The facts in this case.
Counsel, the written retainer's not in the agreement, right?
I'm sorry, Your Honor.
I'm sorry, the retainer agreement between the parties is not in the record, right?
That's right.
Okay, so what do we know about the scope of representation at this stage of this lawsuit?
The representation started with civil matters for several years, and then after the civil matters, there was a criminal matter, which was at the very end, about 5 years later. The defendant represented the plaintiff at the very outset of that criminal matter for a very short time, and then another law firm took over. So that was the extent of the retainer. The fact is that the allegations concerning, for example, a $600,000 payment or transfer of my client's funds to a bank account that belongs to the defendant was unauthorized. That had nothing to do with a legal malpractice claim. There was legal malpractice that was dismissed, obviously, by the lower court, but the lower court rightly found that the claims involving the unjust enrichment and the breach of fiduciary duty was not duplicitous of the legal malpractice. Indeed, those two claims, or the claims about unjust enrichment and breach of fiduciary duty, happened several years before there was ever any legal malpractice, which took place at the time of the initial representation of the criminal matter. I'm sorry.
Keep on.
I'm just pointing out, Your Honor, again, that you have 7 or 8 different causes of action. Several of them were dismissed. The unjust enrichment and the breach of fiduciary duty were not. And there was a very clear reason for that decision, in my opinion, which is that they had nothing to do with a legal malpractice claim.
All right.
Thank you.
Thank you. I will add your 2 minutes that you saved.
Okay, thank you, Your Honor.
Okay, go ahead.
Just briefly, again, there was one representation here, and I think if you look at paragraph 9 of the complaint, the key language is at the time. At the time that Baker Botts was initially retained, Mr. Silver was considering meeting with SEC and DOJ officials regarding his business activities. And I think in that sense, it's notable that in Carmel, which is the seminal case on this issue.
They retained Baker Botts, he retained Baker Botts in 2015-ish?
2015, that's what's alleged, Your Honor, yes.
I'm sorry if I misspoke. And the proffers didn't really start till 2019, right?
Correct, but that's what's alleged, but he says he alleges that between, was at the time, so at the time of the initial engagement, was considering meeting with SEC and DOJ officials regarding his business activities. So that was on the table at the time. And again, it's one continuous representation. I think in that respect, it's worth noting in the Carmel case itself, the defendant law firm did not actually represent the plaintiff in his criminal prosecution. He represented him in a Civil Martin Act deposition before that. And the Court of Appeals explicitly says, quote, defendant never represented plaintiff after the Martin Act hearing.
Again, as my colleague mentioned very early in your first round, it's pleading stage. And they're alleging facts that suggest that it's separate and attenuated from the legal malpractice claim. You claimed it's intertwined, that's fine, but it's a pleading stage. And for example, with unjust enrichment, there are allegations that there was overbilling, there was allegations of misappropriation that have nothing to do with legal malpractice with respect to the advice regarding the SEC. So,
Your Honor, my colleague may have argued that. They may have argued that in the briefs. That's not what they allege in the complaint, and it's all one continuous representation in the complaint.
Humor me for a moment. Let's assume they bring their complaint and they omit a legal malpractice claim. And so their complaint is same other underlying factual allegations, but instead of pleading a legal malpractice claim, they omit that and just go with breach of fiduciary duty and unjust enrichment. Any objection there?
Yes, Your Honor, because I think Carmel doesn't actually, even though it involved a legal malpractice claim, isn't limited to legal malpractice claims. And the language is, from the case, the undisturbed representation of the client's guilt in the subsequent criminal prosecution precludes him as a matter of law from recovering civil damages flowing from the allegedly negligent representation. It's not limited to the cause of action. It's limited to it's the facts, the underlying facts, and that's what we have here.
Okay, thank you so much.
Thank you. Thank you. Nice meeting you. Sure. Good seeing you, Brendan. It's Nish.
Nice to see you in person. Yeah.